না, ওনার কোনো দোষ নেই, আপনার উকিল বাবুর কোনো দোষ নেই। তার কারণ আমার পক্ষে সম্ভব হয়নি, এই কোর্টের পক্ষে সম্ভব হয়নি হিয়ারিং ম্যাটার্স নেওয়া। এটা তো হিয়ারিং লিস্টে চলে গেছে, এই কোর্টের পক্ষে সেটা সম্ভব হয়নি। সুতরাং আপনার উকিল বাবুকে দোষ দিয়ে তো কোনো লাভ নেই। যেটা আমাদের পক্ষে যেটা সম্ভব নয় নেওয়া, সেটা আমরা নিতে পারবো না। আপনাকে অপেক্ষা করতে হবে, না হলে আমি টু বি মেনশনডে আনিয়ে মামলাটাকে আমার বেঞ্চ থেকে এই এজলাস থেকে রিলিজ করে দিতে পারি। আপনি কি সেটা চান? যদি আপনি সেটা চান, কারণ এখন অন্য বেঞ্চ আছে যেখানে খালি হিয়ারিং ম্যাটার শুনানি হচ্ছে। ঠিক আছে, তাহলে এটাকে টু বি মেনশনডে দিয়ে দাও। ও আমার লিস্টে রান করছে না, তাহলে আপনি যেখানে হিয়ারিং মামলা, খালি হিয়ারিং মামলা যেখানে আছে আপনি সেখানে গিয়ে মেনশন করুন ফর ইনক্লুশন ইন দ্য লিস্ট।
May I have lordships kind leave to mention, my lord, a little urgent, my lord, in the sense that your lordship was pleased to issue a rule, my lord, on the officers of the Eastern Coalfield. Now, my lord, the matter went to the Supreme Court. The Supreme Court has given us 15 days time, my lord, to comply with the order. We'll comply with the order anyways. We were just waiting for, my lord, whatever happens in the Supreme Court.
Obviously, naturally. Otherwise, you would have come back saying that there is a stay by the apex court.
We would have, my lord. Now, my lord, fifth is the returnable, my lord. The fourth is the returnable. Gives us, my lord, kindly
Sorry,
just,
I have not appreciated the conduct of ECL. I don't know why Madam Banerjee has asked you to come before me today. But anyway, I have not appreciated the conduct at
I'm
all.
very similar. I bow
But
down
I
to your
cannot.
lordship, my lord.
No, and this is not the way it is to be done. It is a very serious matter. It's a content
But
matter. And
Supreme Court now, my lord, has
I have
modified.
given her enough opportunity. I have extended from time to time.
But now
but,
the Supreme Court, my lord, has given us time.
All right, but still it should come. The Supreme Court may have given you time, but it should come. Because the rule has already been issued.
My lord, if your lordship may kindly, my lord, consider, my lord, then the contempt really, my lord, if your lordship sees.
No, they should have come up with an affidavit of compliance on the last day, because I had actually adjourned this matter on several
I'm
occasions.
so
If you
sorry,
look
my
at
lord,
my last
I
order,
was not there. I would have definitely, my lord.
if that last order is placed before you, you will see that enough opportunities have been granted.
My lord, I saw
But
your lordship was a little
officers
annoyed.
of ECL
My lord
choose
was a
not
little,
to.
my lord was a little annoyed. I found out from the order. My
Why
lord.
should I be annoyed?
No, my lord, they are ready to comply. They were just waiting
No,
for
they
what
were
happens
not
to the
ready
appeal.
to comply. On the last day, they came back and the instruction was to submit that there is a merger,
Yes,
if I remember correctly.
yes.
So they were not at all ready to comply. They
My
were
lord, no, not ready to comply till the Supreme Court, my lord, did whatever
Mr.
it had to be
Chatterjee,
done.
please listen to me. They were
Surely,
not
my
ready to comply with the order. They wanted to put it in the cold storage by saying that there is a merger, so that the contempt application over here fails and this person has to go before the division bench. So this is the tactics that
My lord, I saw, my lord, in the order.
the officers tried to
My lord,
play with this court, and that's why the court had to actually do a lot of homework in writing that order.
my lord, I completely appreciate and I bow
I am
down, my
so
lord.
sorry, Mr. They have to come, and on that day they will have to come and say what they want to say. That the Supreme, this is not the way. Why are you mentioning? This is not the way. A
Well,
contempt application rule has been issued. They will have to come and say that they need time
May I
for
pray for
affidavit of
one thing?
compliance.
May I pray for one thing? My lord, there are the chief general manager, everybody, my lord, is involved. They are probably
Somewhere the line has to be drawn.
any
Somehow,
one of them.
the line has to be drawn. And if you want, you can again go back to the apex court and say that this court is not willing to
I'm not
extend the time for compliance of the rule, because the rule has already been issued, and this is not the way the rule can be
even,
varied.
even contemplate. I would not even have, my lord, bothered your lordship. But since
No, this is absolute. I have not appreciated your mentioning at all. Very honestly, I have not appreciated your mentioning. You should not have come.
I bowed down,
Actually,
my lord.
you should not
I
have
had
come.
to communicate, my
Because
lord,
of
what
this, the rule has been issued after giving so many opportunities, and you have seen what the conduct of the ECL was.
I bow down, my lord. But
You should not have
since
mentioned this matter at all.
I thought, Lord, because the Supreme Court had extended the time.
Is this the way?
Lord,
Once the rule has been issued, to come and say without coming with an affidavit of compliance on that day.
I have, my lord, instructions. I have given instructions, my lord, to
Is
prepare
this
that.
the way to come and mention?
To prepare.
I have
was
not
just trying to
appreciated.
save, my lord, their
I am so
personal
sorry,
appearance.
Mr. Chatterjee. This case, I have not appreciated your mentioning at all.
I was just trying to save, my lord, the personal.
Please do not argue
your
anymore. I have not appreciated. I have
As your
expressed my mind. You should not have come to mention this case.
I'm extremely sorry, my lord. I was just trying to, my lord, it's okay. Perfectly fine.
No, this is absolutely not the way.
No, my lord. I bow down,
A
but
rule
I
has
thought,
been
Lord,
issued. What is this? This is not a very
I thought I
light
needed to,
matter.
my
It is a
lord,
very serious matter.
I just wanted to, my lord, communicate the decision, my lord. There's nothing.
Mrs. Banerjee could have done it, and this is the way.
Definitely, my lord.
Once the rule has been issued.
I bow down, my lord. I bow down. The rule was issued earlier, my lord. This happened later.
So,
Just need to
once the rule has
communicate
been
that.
issued, is this the way? If there was a stay, then it would have probably been different.
No question of because the time was extended. That's why I thought, my lord, that the contempt might
I have not
be-
appreciated.
might
This
not
much
be-
I can say.
Cali doesn't take me amiss.
No,
but,
you should not have. There are times when people like you have to communicate to the instructing advocates which matters you should mention and which you should not.
I bow down.
It is up to you.
No, my lord. I completely bow down. Completely bow down.
You should not allow them to do all this.
I completely bow down.
People like you should not.
No, my lord.
You will be the leaders of the bar. You should not. Mr. Chatterjee, this is very serious.
I bow down.
You should not have acted upon the instructions of ECL in this matter.
Sorry, my lord. I'm extremely sorry. I'll be back on the 4th.
This court has a lot of respect for you, but
No, my
you
lord,
should not have done this.
I'll come back on the 4th. My lord, Cali doesn't take me. I'll come back on the 4th.
May I be permitted to mention two matters? The last occasion, your lordship restored those matters.
Then what happened?
I'm paying for listed in.
Give the slip.
I'm paying.
May I have your lordship leave to mention, my lord, in this matter, my lord, last occasion, their respondents are not receiving the writ copy. Even also, I mentioned before your lordship. And
What are they not doing? Please speak on the microphone.
yes, my lord, this matter, my lord, the respondents, my lord, the Union of India, they are not receiving any writ copy, even also notice. I mentioned before your lordship at the time of
Have I not directed it to be served on the learned senior
lordship,
advocate, Ministry of Law and Justice?
Yes. Lordship directed me to serve the copy. Even your lordship's order has also given to them. In spite of your lordship's order mentioned that they refused to accept them. They have stated, send it to the general manager, railway. That, my lord, matter is appearing 108. My lord,
All right, let it be called on. I will have someone else appointed. Let it be called.
Railway, if I'm not wrong, railway doesn't come under Ministry of Law and Justice. Probably
The
that-
Union of India is a party, sir. Union of India should have accepted service pursuant to the directions of the court.
yes.
Let the matter come. I shall.
Item number 1.
Direct.
Petitioner, Your Lordship, this is my affidavit
না,
of service, Your
না,
Lordship.
কিছু বলিনি।
Your Lordship, this matter, my lord, this matter relates to the promotion to the post of junior traffic supervisor from the post of.
Why have you not filed your opposition?
Your Lordship, a subsequent petition has been filed challenging the
Shorun bhai.
promotion order, which renders.
Very good. That means that you will not file your opposition to this writ petition.
Your Lordship,
Is that an excuse for you not to file?
I was instructed to submit this as it falls from the bench. Your Lordship, we are ready to.
Falls from the bench, there are directions. Why have you not complied?
This is a direction of the line. Factual because of the new.
So let the writ petitioner submit. You cannot be, being a respondent, you cannot come and say it has become infractuous. Let her submit. So now how long will you take? In July, 1 year you have taken, you have not filed your opposition and now you come and say it's infractuous.
Well, may I pray for indulgence, Your Lordship? Instead of opposition, if they file their report, that may be expedited, Your Lordship. The matter.
What are you saying, madam? This is an order passed by a coordinate bench. Why are you making such submissions?
I'm sorry, Your Lordship. Opposition. is-
Now you're asking for variation of that order.
No, I'm not. I'm sorry, Your Lordship.
Please don't make unnecessary submissions.
I'm sorry, Your Lordship.
By an order dated July 11, 2022, a coordinate bench of this honorable court passed directions for filing of affidavit in opposition by the West Bengal State Transport Corporation within bracket WBTCL bracket closed. Full stop. On the prayer of Ms. Dotto, learned counsel appearing on behalf of WBTCL. Time to file affidavit in opposition is peremptorily extended till August 25, 2023, full stop. Reply, if any, by September 1, 2023, full stop. Parties will be at liberty. Okay, next paragraph of it. To mention the matter for hearing, bold it. Upon expiry of the time stipulated for exchange of affidavits, full stop, server call. Mr. Mitra, you don't have anything to say
No, no,
between
no.
the corporation
Yeah.
and the employee.
Yes. Grateful.
Item number 2, my lord, yesterday the matter was heard by your lordships, my lord, and the matter was fixed on 17, my lord. On 17, my
Yes,
lord,
I kept it because he has some problem on the 17th.
21st.
1 minute. 21st instead of 17th. What a returnable data shop to dewa ache khali returnable date 21st of September kore deben.
September, August.
Sorry, August. 21st of August. কালকে কি হয় আজকে ডেটে অর্ডারটা তো দেওয়াই আছে খালি 21st August.
Good.
That's matter, my lord. Your
I'm
lordship
for the petitioner, my
directed
lord.
for filing supplementary affidavit by the petitioner, my lord,
petitioner
probably by
do not want to-
28th, my lord.
My lord, petitioner.
Of you speaking at the same time, I can't understand.
Exactly. My lord, your lordship directed on the last occasion in this matter, my lord, there are 3 matters, my lord, regarding disciplinary proceedings connecting to this
All
coal
right,
scam,
all
my lord. So they were to file within 28th.
They have filed a supplementary.
My lord, petitioner do not want to proceed with the matter. Over the text, they have informed us.
They have
But
not
if
served a
your
copy on us
lordship kindly allows.
of the supplementary evidence.
Madam, sir, this order has to be passed on that day. After that, you pray for not proceeding with the matter because I have made certain comments. Those comments have to go in against the petitioner on that day. So now, at present, I cannot allow that prayer. Let me first pass this order because the necessary documents on which the petitioner was praying, those necessary documents were missing.
Well, through supplementary affidavit, we have requested your lordship to submit the.
Yes.
They have
Supplementary
not-
affidavit
Well,
was
in that instant, the petitioner replied us they do not want to proceed with the
They
matter.
have not
Where
served a
is the
copy.
you have not filed the supplementary affidavit?
My lord, he is not coming for affidavitting the supplementary.
By
affidavit.
direction of your lordship, the petition has not come forward to affirm the supplementary affidavit. It's in
এইটা না এখানে একটা প্যারাগ্রাফ অ্যাড হবে 18 তারিখের অর্ডার। হ্যাঁ ঠিক আছে, আমি এটাকে আগে আমি 18 জুলাইয়ের অর্ডারটাকে ঠিক করি। এই যে ইন সাচ ভিউ অফ দ্য ম্যাটারের আগে একটা upon perusal of the facts of the case and the materials placed in the writ petition, it appeared to this court that the documents necessary for praying stay of the disciplinary proceedings was not annexed to the memorandum of charges, full stop. Therefore, comma, this court finds it perplexing how the petitioner can pray for stay of departmental proceedings without placing the necessary papers on record, full stop. Therefore, the court could not consider the prayer for interim order of stay and gives liberty. না, gives liberty. আচ্ছা, তারপরে তো in such view of the matter, the court is এটা আছে এটা করে দেবেন। তারপরের অর্ডারটা পরের দিন তো ঠিক আছে। Today it is submitted. এটা আজকের অর্ডার হচ্ছে। That neither the petitioner is inclined to file the supplementary affidavit, nor is willing to proceed with the matter. Full stop. Written instructions with regard to the same is handed over in court today and retained with the records. Full stop. Next. This court is of the view that substantial judicial time has been wasted in dealing with the issues raised in the present proceedings. Full stop. Therefore, this court dismisses the writ petition with costs assessed at rupees 10,000 to be paid to the State Legal Services Authority. Full stop. Next. Legal services within a month from date. Full stop. Next. Let the matter appear for further consideration under the heading to be mentioned on September 11, 2023 for showing necessary compliance of the court's order. Full stop. Next. Unless the petitioner puts in the costs within a month from date, appropriate orders within a month from date, appropriate orders will be passed against the petitioner. Full stop. Serve a copy. To be mentioned আর ওই ডেটটা একটু বোল্ড করে দেব। Once the petitioner puts in the cost, I will consider the prayer for withdrawal. Enough judicial time has been wasted. Otherwise necessary appropriate orders will be passed. Please indicate to the petitioner. The court knows how to pass appropriate orders.
My lord, I am for the state respondents, my lord.
I am on behalf of the petitioner, my lord, led by Mr. HON'BLE, praying for not today, my lord.
He is not well. Last
No,
time you submitted.
he is well. He is engaged in code number 550.
7th August.
7th.
7th August. Next time new motion will be coming up on 7th of August.
5.
Also, my lord, I am for the respondents.
A helpless lady before your lordship. She was
Yes, Mr. Jahan.
engaged- She was
I can't hear you on the microphone.
a helpless ladies before your lordship. She was engaged as my lord Anganwadi helper in
Yes.
2007. Page 20 is my admit card. 20.
Yes.
An engagement is at page 21. Subsequent thereto, my lord, she continued her duty, but
Page 20,
is 22-0, that's my admit card.
21 is your engagement
21
letter.
is my engagement.
From when is your engagement?
Page 20, my lord,
From when, July 2009,
2007.
2007?
Yes.
No,
I'm sorry, no, that's 2009.
2009, July 2009.
I'm sorry. From 2009, my lord, she had been continuing. Now, in a subsequent stage, due to political changes and some other reason, my lord, she was restrained to perform duty. After a long battle, she approached this honorable court, while this honorable court was pleased to direct the authority to consider her grievances and to take a final decision on that, page 54. January 5th, 2023.
Yes.
Now, there the authority was directed to my lord, take care of the entire situation and to consider her grievances. Page 58, that's the reasoned order passed by the authority.
Yes, now, Mr. Jahan, what do you want this court to do?
My lord, I was directed to resume my duty in 2016. Page 22, I lost my general diary. Page 26 onwards, I went there. I was not allowed to enter. Once again, I lost my complaint before the authority. And those are on record. Page 25 onwards, kindly have a look, my lord.
Yes, but you have been praying, if you come to page 27, you have been praying to work there only. If you look at the penultimate paragraph at page 27,
It's page 27.
page 27 penultimate paragraph, if you see, this lady only wants to work there only.
Yes. There I was directed.
The lady is only willing to perform at ward number 198. The lady has been given an opportunity to go and work somewhere else, but the lady wants to
But
work there only.
they didn't disclose any center. Go somewhere else.
Absolutely incorrect.
Or my lord, I was directed
Absolutely
to
incorrect. Well, page
Yes.
58,
or
CDPO directed her to join any CDP,
can
Yes.
that be
any center of her choice within Purbo Kikapur Gram Panchayat. Kindly
Now,
consider page 58.
Mr. Rai Mukherjee, if she tries to, you tell me which are the centers. And if she tries to join, the only grievance is that she has not joined and she only wants to work at 198. 198, she has created some problems. There are allegations
Yes,
against her.
yes,
These are
yes.
factual in nature. I cannot go
Yes,
get
ma'am.
into it. But after all, she's a poor lady. So the court has to consider. Now you tell me which are the centers
Very-
which are near 198.
Very. My lord, your lordship kindly consider page 58, the second last paragraph. My lord, I shall furnish all the Anganwadi center. My lord, kindly consider this last, second last paragraph. The monthly honorarium of Srimati Ishmatara Bibi was stopped with effect from February 2016 due to her not marking her attendance in CDPO office for a long period of time prior to February 2016. Subsequently, she was directed video memo.
Yes, that I have seen.
Yes.
Now what you do is that please produce this memo
Yes.
by which you have directed her to, you will do 2-3 things. I will direct. First, you will produce this memo. Then you will show me how you have served this memo. And then you will tell me which are the centers which are near 198.
Very good.
Because
Or-
you are saying that she only wants to work at
or my lord,
198.
if they come with proposal of any Anganwadi center,
My lord, I will
Well, she is
furnish
just-
Now,
a
after
list of-
2006, she has come to her senses, Mr.
yes,
Jahan.
he is ready to go.
No, now she has come to her senses after
Yes,
2016.
yes.
Not
With-
working, not having any
with her
money.
daughter being a single mother,
Yes.
she's not in a
How-
position to feed herself. Now she realized the situation.
Now she has realized the situation
Yes,
after
yes.
2016.
Yes, my lord.
Not working, that what is the position?
So she would not get the in between honorarium. My lord, kindly save her. Kindly save her.
No. Now the honorarium will only be considered after she joins. How?
Yes.
What I am not getting into the question of honorarium. First, let me see how they have served this memo upon you and
Yes,
what is
that-
the
that-
text of the memo and what are the centers in that area.
Yes.
Then the lady will be asked that which center is near her place of residence.
Great. my lord.
Because the court has to balance. If she is
Yes, yes,
sent to a
yes.
center which is far off, she will not be able to commute and pay the money. So now I will have to get into that.
Just few days back, my lord, we have come across the persons who have been working at Joynagar in MSK and SSK. They were directed to resume duty at Jalpaiguri.
It
And
is not
court come
possible.
down heavily.
It is not possible.
Yes.
Now one has to see, because if she's a single mother, she has a child, she has to look after, she will not be able to spend that kind of money
I'm pardon to lordship.
unless the state arranges for her commute.
When Mr. Rai Mukherjee is
Transport and
here, my
commuting.
lord,
If Mr. Rai Mukherjee assures that that will be taken care of, then that will be possible. Ashwin. Hmm,
Revenue service be kept on it.
Mr. Jahan, Learned Counsel, appearing on behalf of the petitioner, places the reasoned order dated March 21, 2023, passed by the Child Development Project Officer within bracket CDPO bracket closed, comma, Barasat -1 bold A, ICDS project, comma, not 24 Parganas. Full stop. The said reasoned order has been passed pursuant to an order passed by an honorable coordinate bench of this court on January 5, 2023. Full stop. Such reasoned order is impugned in the present writ petition. Full stop. Next. The petitioner has been working as an Anganwadi helper within bracket AWH bracket closed since July 20, 2009, full stop. The petitioner's honorarium was stopped from February 2016, since she has not been marking her attendance in the office of CDPO long prior to February 2016. Full stop. Next. The petitioner was directed to resume her service either at Anganwadi Center, AWC bracketed mudde, number 198, or take bolde, any other AWC of her choice at Purbo Khilkapur Gram Panchayat, within Purbo Khilkapur Gram Panchayat. Full stop. Next. It is the contention of the petitioner that she was prevented from resuming her duty as AWH at AWC 198 due to circumstances beyond her control. Full stop. The authorities noted that the petitioner has persistently expressed her disinclination to join duty at any other AWC apart from AWC 198. Full stop. Next. Under the memo dated December 10, 2009, issued by the Government of West Bengal, Department of Women and Child Development and Social Welfare, the period of absence beyond 6 months at a time without honorarium may be extended for a period of 1 year in the case of serious ailments warranting hospitalization or confinement to bed, where AWWs and AWHS do not attend their duty. Full stop. However, there was no provision to extend the time beyond that period. Full stop. Therefore, due to long period of absence, the prayer of the petitioner to rejoin her duty was rejected by the impugned order. Full stop. Next. Mr. Rai Mukherjee, learned counsel, appearing on behalf of the state respondents, submits that there is no infirmity in the decision-making process of the authorities. Full stop. The petitioner consistently refused to join her duty. Full stop. Therefore, the authorities were not at fault. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that justice will be subserved by directing the state respondents to submit written instructions before this court by producing the memo dated February 5, 2016, and also a list of AWCs, choto, in Gram Panchayat, in GP hyphen Purbo Khilkapur, full stop. When can you bring?
Well, may I just indicate one thing? My lord, this memo dated 5th February 2016 is at page 24 of this writ petition. She received this in the pleading, my lord, paragraph 7 at page 6. Page 24, my lord, it was addressed to her, and paragraph 7 at page 6, my lord. Your lordship will find that she received it. Yes.
Can you just, because it's very,
My lord, there is no denial, my lord, from paragraph.
no, can you just read it?
Yes,
এত
yes,
দ্বারা
yes.
এত দ্বারা আপনার অবগতির জন্য জানানো যাচ্ছে যে গত 19/1/2016 তারিখে বারাসাত 1 নম্বর পঞ্চায়েত সমিতির অন্তর্গত বিডিও ম্যাডামের অফিস গৃহে জনকল্যাণ ত্রাণ ও স্থায়ী সমিতির সভায় সিদ্ধান্ত অনুযায়ী আপনি যদি আপনার নিজস্ব কেন্দ্র বা পূর্ব খিলকাপুর গ্রাম পঞ্চায়েতের অধীনে যে কোনো অঙ্গনওয়াড়ি কেন্দ্র বা প্রকল্পের অধীনে উপস্থিত না দেন
উপস্থিতি না দেন
তাহলে আপনাকে ফেব্রুয়ারি 2016 তারিখ থেকে সাম্মানিক ভাতা দেওয়া হবে না। উল্লেখ থাকে যে আপনি জুলাই 2015 তারিখ থেকে ডিসেম্বর 2015 তারিখ পর্যন্ত বিনা পারিশ্রমিকে পারিশ্রমিক বাবদ সাম্মানিক ভাতা পেয়েছেন। বিষয়টি আপনার অবগতির জন্য জানানো।
আসুন, ওইটা কেটে দিন, মেমো ডেটেড 5/2/2016 টা না, লিস্ট অফ দ্য অঙ্গনওয়াড়ি সেন্টার্স খালি করে দিন। Yes, when will you come back?
Within 2 weeks, my lord.
Let the matter come up for further consideration under the same heading motion bolded on August 24, 2023, bolded, server copy. Just get the list, then the problem can be solved.
Great. Great.
Autonomous is on behalf of the petitioner paying for not today.
Why? Mr. Pal.
Sushant Pal. 6 and 8 also, my lord.
No, let me see who is in 8. এটা কবে রাখলাম, অন্যটা কবে রাখলাম? 7 তারিখ, 7th.
7th. I'm grateful, man.
7.
I'm for the petitioner, Lordship.
My lord, in item number 7, Mr. Devashish Basu is appearing in this matter for Union of India. He is down with fever, my lord. He could not come to court. He has prayed for not
7th.
to.
I'm present.
Good.
8.
8, my lord. Paying for not.
7th.
Grateful.
7.
Yes.
7, 8.
9.
7th.
7. Item number 9.
May I please, your lordship? My lord, to some extent, this is a peculiar case. The petitioner is a, my lord, Anganwadi worker.
Yes.
The government took one policy that out of the new selectees, 50% would be selected from the in-service categories of Anganwadi workers and female categories. But I was a candidate.
For supervisor, post of supervisor.
Supervisor.
Yes.
My lord, I was called in the test. On 2 days, my lord, I appeared in the written test. I did well. But in the panel, my name is there, not there. She is under apprehension because she is highly qualified and working as an Anganwadi worker. She applied under the right to information that you give me the numbers, which I have got. That was nothing has been done. Then, my lord, we made a representation through learned advocate, page 26, but nothing has been informed. So, my lord, the position is that as per policy, my lord, as per policy, it din kindly. My lord, from this policy to appear that it to din na. Hey. We appeared in the examination, my lord, that was formality. Clause 3, my lord, sub clause 1. The 50% of vacancies in the post of supervisors would be filled up by promotion from amongst the Anganwadi workers with 10 years of experience as Anganwadi worker and having the prescribed educational qualifications as per the recruitment rules for the post of supervisor, failing which the vacancies would be filled up by the direct recruitment and remaining 50%.
Now you have made this representation, let them consider the representation.
Yes.
When have you
yes,
made it?
Yes, yes. Let them,
The examination was conducted by the PSC. They sought in the answer script from the under the Right to Information Act, but they have not made PSC the party.
Now you dispose of their representation. Why have you preferred a first appeal?
No.
Why have you not preferred a first appeal?
Because, my lord, we
After expiry of 30 days?
30 days, yes.
Yes. Anyway,
Let them, my lord, Additional Joint Secretary,
you
Department of
have made this representation on April
June
12th.
June
That is
14.
your advocate's letter. Your representation is at April 12th, 2023. At page 25.
Yes, that is 25.
Yes, so let them consider your representation and
Yes.
pass a reasoned order.
Yes.
Ashu. The petitioner's case is that she is working as an Anganwadi worker within bracket AWW in the Integrated Child Development Service within bracket ICDS bracket close projects full stop. The petitioner was appointed as AWW in 2009 in block, comma, Shutahata, block
1.
Shutahata -Roman 1, comma, district Purbo Medinipur, full stop. Next. Learned counsel appearing on behalf of the petitioner submits that as per the recruitment guidelines dated September 15, 2015, issued by the Ministry of Women and Child Development, Government of India, 50% of the vacancies in the posts of supervisors would have to be filled up by promotion from amongst AWWS with 10 years of experience and having prescribed educational qualifications as per the recruitment rules
So highly qualified.
for the post of supervisor. Full stop. The remaining 50% of the vacancies would be filled up by direct recruitment. Full stop. In the event 50% of the vacancies cannot be filled up by way of promotion, the same may be filled up by way of direct recruitment. Full stop. Next. A copy of the said notification as handed over in court today is retained with the records. Full stop. Next. Learned counsel appears on behalf of the state respondents and submits that despite the fact that no response has been given to the Right to Information Act, to the application under Right to Information Act, 2005, made by the petitioner, the Public Service Commission has not been made a party to the present proceedings. Full stop. Next, considering the rival submissions of the parties and the materials placed on record, this court directs the representation dated April 12, 2023 to be considered by the director, ICDS, stroke, the respondent number 2, on the issue why the petitioner was not promoted despite having the requisite qualifications and completing 10 years of service as AWW. Full stop. Let such representation be considered within 8 weeks from date upon giving a personal hearing to the petitioner. Full stop. A reasoned order that may be passed be communicated to the petitioner within 2 weeks of passing thereof. Full stop. Next. With the directions aforesaid, WPA 16150 of 2023 bolded is disposed of bolded. Next. Since no directions for affidavits, server copies, certified copy. What else?
No, nothing, my lord.
Grateful morning. Sure.
And I beg to appear on behalf of the petitioner, madam. May I file my?
No, নাম দিয়ে দেবেন তাহলে Mr. Rai Mukherjee, learned counsel. Yes.
Madam, may I file my affidavit of service, madam? These are contractual Ayush medical officers with the government of West Bengal. These are contractual persons, not
You
permanent.
paid the court fees.
Madam, I'm told that only one for one it has been given.
But I have
I'm
got the
extremely sorry. I should
preliminary
have.
objection about the materiality of the application.
Yes.
But kindly see page 15 prayer
50.
15.
Yes.
But kindly see written in the nature of Shashi quashing the transfer order dated 1st March 2023. That is at page 80.
Washing the orders dated such and such. Page
Page 80.
80.
80. How many persons were transferred? Kindly see. None of them made parties. But a total 118 persons were transferred on that. None of them made parties.
All right, let me see whether what his prayers are today.
And prayer 8.
He may not be interested in their quashing of their transfer orders. He may be
Kindly
interested-
see. Kindly see. Prayer made for quashing the transfer of
All right, let
118
me
persons.
see what he's praying for today. He might be wanting the authorities to consider his transfer.
No, but a consider has been made.
Consider-
Consideration has been made in terms of my lord's order. But he has not selected any person place. Because in the vacant post, he can be considered. Kindly see that is the last order.
Mr.
for-
Yeah,
Mukherjee,
may I-
you are not letting him place his case. First, let him place his case. You're not letting him. It is his writ petition. Wait, yes.
Madam, these are Ayush medical officers, madam, wanting transfers. I'll just come to the transfer guidelines first, and thereafter I'll proceed with the
Yes.
writ petition. My lord, will kindly come to page 71, my lord.
71.
71. These are the transfer guidelines for these people.
Yes.
Eligibility is clause 2, 2.1 is relevant, my lord. Any contractual employee will be eligible to apply for transfer if the employee has served for at least 6 months or more in the current post.
All right.
For mutual transfer, there is 2.4 as well, page 72, that if there is availability, then only transfer requests will be accepted.
Naturally.
So my lord, if there are two transfer applications, can one be transferred and the other be not, in respect of the of the same place? And can my transfer application be rejected on the ground that the other application was allowed, but mine was not? Although it
One
was-
has to see chronologically whether yours is before or whether yours is after. One has to see how the vacancies are to be filled up. Now you tell me what has happened. Where is my previous order?
My lord, the
My lord,
previous
the
order
order
is page 137, my lord. This is an order of consideration, my lord. I'll come. I'm sorry, my lord. May I place the relevant portion of this order, my lord?
Wait, just a minute.
137, my lord's order.
I have already said that I am not willing to consider the prayer for quashing. In the previous order, I have already said
No,
that.
but if we are an earlier writ petition, the
Yes.
same prayer was made, then but by res judicata, and apart from that,
Yes, still nothing prevents them.
then
from
first,
making.
first he shall have to withdraw the prayer.
They will wait. They will. Now let me see what he wants.
Now, kindly consideration at page 144.
While drafting, he has put everything. Now let me see what he wants. Yes. Now what they have said in the reasoned order.
I will kindly come to my transfer applications first. I'll come to the reasoned order immediately
No,
thereafter.
you have to show me the reasoned order first.
Page 144.
Page 144 is the reasoned order, my lord. Page 141 it starts rather. May I read out the relevant portion, second paragraph? The instance matter is being heard out today. All the 5 petitioners are present. Shuchandrima Das, Shumir and petitioner submitted the following documents. I will kindly come to the last paragraph of page 142. Many transfer applications could not be considered as there is no available vacancy as per the desired facility given in the choice of place of posting of. No specific facility is mentioned in their given choice of place of posting. All candidates whose transfer application could not be processed due to non-availability of vacant facilities as per their choice of posting will be called for counseling on 29th May 2023 for male and 30th May 2023 for female. For giving them a fair chance, it may be noted that the process of transfer for the post of medical officers under RBSK is still under process. The matter is urgent for the day. So I was called, I am for the female ones. The male people already got transferred. They are not writ petitioners anymore. They were writ petitioners in the earlier writ petition.
I have understood all of that. Now you see, you take me to the place why you were not transferred.
My lord, will kindly come to the order dated 30th May. Today is fixed for counseling for female medical officers, all 5. Shuchandrima Das. Shuchandrima Das is the petitioner number 1. My lord, Shumita Das and Bonasri Mondal. After considering the submissions of the petitioner number 1, 3, and 4, and having examined all documents and papers on record in accordance with the vacancies, following issues have emerged. Petitioner number 1, Shuchandrima Das, and petitioner number 4, Bonasri Mondal, refused to choose any health units from the available vacant health facilities for female posts under MO Ayush RBSK and opted to stay at their current place of posting. Petitioner number 3, Shumita Das, chose.
So now, why you have filed this writ petition?
But these are the two. That is why I was coming to my transfer application, and in those centers itself, other people have been posted
One
in
has
the.
to see whether they have applied before you or not. There must be a reason for how they have
They have to.
effected the transfer.
My learned
Kindly,
senior.
somebody does not. But kindly say the language.
Kindly let me place the transfer applications for once, my lord.
Yes.
Page 18 is the transfer application of Dr. Shuchandrima Das, my lord. Page 19 is the relevant portion, my lord. First choice is North 24 Parganas, Rig Jaumi, BPHC, Rajarhat, 2 block. My lord, will now compare this with page 80, my lord.
Page?
80, my lord. 80, my lord. Annexure P6, page 80, my lord. My lord, will kindly consider serial number 10. This
No,
was.
that I will not get into. That I will not get into. You don't have to show me that. I will have to see the reason for choosing other people over you. That is how they have to show
my
me.
lord,
And show me the other application.
my lord, in the respect of the other application is at page 57, the relevant portion at 58. 58, my lord. The first choice is Baripur block. My lord, will kindly compare this with page 80. Serial number 5. The third choice is Mongrahat 2 block. And page 80, serial number 5 is also transferred Mongrahat 2, Diamond Harbour HD. So the exact places I want to transfer to has been given to somebody else.
Yes, maybe they have, there must be a reason. That reason, they cannot take an arbitrary decision. They will have to place that reason before this court.
That is all I'm asking for, if that reason may be placed.
Well, can you see page 144 for a moment?
Yes.
Pursuant to Malad directions, they have considered. Petitioner number 1, Dr. Suchandima Das. Petition number 4, Bonasri Mondal.
Yes, you are saying there are no available
No, what can you see?
vacancies.
Refused to choose any health units from the available vacant health facilities for female posts.
Yes, I have seen that.
Opted to stay at current place of posting.
Yes, because you were not giving them posting at their place of choice.
No, what can you see? He opted to stay at the
Yes, because you were not giving them posting at their place of choice.
until unless vacancies there.
Yes, now I have to see how you have given it to others, whether they have applied before or not. There has to be no arbitrariness in your decision-making
No,
process.
what can you see? We shall have to run the administration.
Yes,
Healthcare center.
yes.
If somebody there, no, I shall have to give in the place for posting in my home district. Then, madam, we should cannot run the administration. Transfer for the,
Mr.
for the
Mukherjee.
interest of public.
Yes, I am not saying anything. There were vacancies in those centers. He has shown me from the list. How have you chosen the other candidates and not these candidates? I have to see by choosing the other candidates whether you have used your discretion properly.
What can you see? 1st March 2023, order of transfer was issued in respect of 178 persons. When the same order was challenged before the lordship by a writ of certiorari and a writ of manama, Malad refused to stay there. Can that prayer be made?
I have to see how you have, because you have not altered that order. You have not said that these people have applied before. Today, if you do not consider the petitioners, and if you unfairly consider someone else, will the court be powerless to get into that?
I'm not saying that. I'm not saying that. On the 1st March 2023 order.
Please listen to the order. Listen to the order, Ashu. Pursuant to the direction. Where is the previous order? Directions passed by this. I found it.
My lord's order at page
137.
137.
Pursuant
Sorry.
to the directions passed by this court.
137 to 139.
April 11, 2023. In WPA 5580 of 2023. The executive director, West Bengal State Health and Family Welfare Samiti, Department of Health and Family Welfare, considered the representations / transfer applications of the petitioners therein, and passed a reasoned order dated May 10, 2023, full stop. Next. The petitioners are contractually engaged medical officers within bracket Ayush, bracket closed, full stop. By the reasoned order, which is reasoned order, which is impugned in the present writ petition, the executive director held that the petitioners refused to choose the health units where vacancies were available for the post of female MO within bracket Ayush, and opted to stay at their current place of posting. Full stop. Next, Mr. Ghosh, learned counsel, appearing on behalf of the petitioners, submits that other candidates have been posted at the place stroke choice of posting of the petitioners by the transfer order dated March 1, 2023, full stop. The reason why the other candidates were given preference over the petitioners have not been disclosed by the authorities. Full stop. Next. Mr. Mukherjee, learned additional government leader, submits that no vacancies were available at the centers which the petitioners exercised choice in favor of. Full stop. Therefore, after opting to stay at their current place of posting, the petitioners cannot challenge the same. The petitioners cannot now challenge the same. Full stop. Opted. He also submits that prayer D of the writ petition for quashing of the transfer orders cannot be made, since they are barred by the principles of res judicata, R capital, J capital, italics, full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that justice will be subserved by directing the state respondents to file written instructions on the issue, why the petitioners' applications, petitioners, SL for apostrophe, applications for transfer were not considered, and the applications for transfer of the candidates appearing at serial numbers 5 and 10 of the transfer order dated March 1, 2023 were considered. Full stop. The reason behind according such transfer to the other candidates will be brought on record by way of written instructions. Full stop. As you please. When can you bring the written instructions? 4 weeks. Next, let the matter appear for further consideration on August 24, 2023, August 24, 2023, bold under the same heading motion bolded, when written instructions will be produced on behalf of the state respondents. Full stop. Serve a copy.
Deeply. Careful.
Acha, prothome undertaking is given on behalf of the petitioners to file deficit court fees by tomorrow, i.e. August 2, 2023. Full stop.
Deeply.
11, my lord, I am appearing for the petitioner. In this matter, Mr. Rudrajyoti Bhattacharya is appearing for the respondent. He left the court because of some urgency. Can we make it not today?
Not today.
Great.
My lord. My lord, I am for the
State.
You're appearing for?
State, my lord. Item number 12.
Yes.
My lord, the petition.
On the microphone, yes.
My lord, the petitioner has been working as an Anganwadi helper in center number 88, Ramrampur village. Thereafter, my lord, the child development project officer, Barwan ICDS project, published a notice inviting applications for promotion from Anganwadi helper to Anganwadi worker. On-
Supervisor.
No, my lord, Anganwadi helper to Anganwadi worker, my lord.
Where is the notification?
My lord, the notification is not there, but the admit cards are there.
All right.
My lord, thereafter the petitioner made an application and admit card was issued in her favor, my lord. But thereafter, the date was fixed for written examination on 22/1/2023. But without informing, the examination was cancelled on that date. And thereafter, it was fixed on 8/4/2023 without any prior notice. The petitioner somehow came to know about the same and then took a printout of the admit card from a cyber cafe and then appeared in the.
Initially, it was to be held on 8th April.
No, my lord, it was initially to be held on 22nd January.
22nd January, and then it was held on 8th of April.
8th of April.
Then
Thereafter, my lord, she had cleared the examination and she was called for oral interview, my lord.
all right.
But in the interview, my lord, she was not asked any questions. She was asked only for her name and address. And thereafter, she was asked to write the same down along with her roll number on a piece of paper and she was asked to leave.
All right.
Thereafter, my lord, she came to know from a reliable source that the panel has been prepared, but it has been modulated.
It has been
Modulated, my lord. The favored candidates have been chosen by the authorities, my lord. They have firstly, my lord, they changed the date and without informing the.
She appeared and she was called for an interview. Now she cannot get back to that. Now what has happened?
My lord,
She wants her marks of the interview.
My lord, she has made a representation regarding the same, my lord.
Yes.
Kindly, my lord, consider the representation.
All right. You consider the representation, Mr. Basumali, as per your applicable rules and.
So far the allegations are concerned, I have instruction, my lord. Everything has been done in accordance with the law and rules, and she has been called, she has participated. Now, my lord, all on a sudden, she has come up with the petition by saying all this.
My lord, but the
Dispose it off, saying that all the
Lordship.
all the rules and all the guidelines have been complied with.
Complied with. Got that.
The petitioner is working as an Anganwadi helper, AWH bracket closed, in Anganwadi Center within bracket AWC bracket closed, number 88 in Ramrampur village. Full stop. The Child Development Project Officer within bracket CDPO bracket closed, comma, bird 1, published a notice inviting applications for promotion from AWH to Anganwadi workers within bracket AWW bracket closed, full stop. The petitioner was successful in the written test, full stop. Thereafter, the petitioner was called for written test held on April 8, 2023, full stop. Thereafter, the petitioner was called for personality test stroke interview on April 24, 2023, full stop. Next. Learned counsel appearing on behalf of the petitioner submits that the petitioner has now come to learn that a panel is being prepared by the state respondents by giving preference to their preferred candidates, full stop. Apprehending such preparation of panel, the petitioner made a representation to the CDPO on May 19, 2023. Full stop. However, the said representation has not been considered till date. Full stop. Next. Mr. Bashu Mullik, learned counsel, appearing on behalf of the state respondents, submits that there is no infirmity or illegality in the preparation of the panel made by the CDPO. Full stop. He also submits that after participating in the selection process, now the petitioner is challenging the same. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that justice will be subserved by directing the CDPO to dispose of the representation of the petitioner. To dispose of the representation dated May 19, 2023, of the petitioner within 8 weeks from date. Full stop. A reasoned order shall be passed and communicated to the petitioner within 2 weeks of passing thereof. Full stop. With the directions aforesaid, WPA 16221 of 2023 bolded is disposed of bolded. Full stop. Next. Since no directions for affidavit, next. Server copy, certified copy.
Grateful, ma'am.
30.
So for 13 is concerned, I am on behalf of the state.
My lord, 13.
Same.
All ready to give your appearance.
My lord, I am for the petition. My lord,
Yes.
13, my lord.
You are for the petitioner.
Yes.
Same.
Same.
Date of interview.
Yes, my lord. Everything.
Same.
Same cause of action. Ma'am.
Same cause of action.
And
Same
when
village,
and the center is also same. Yes.
Yes, ma'am.
8.
My lord,
So the name has been changed in case of Basu Malik. No, it was Basu.
Same খালি ওনার নামটা Mr. Basu Malik submits ওটা ওনার নামটা দিয়ে।
Navajit Prasad Basu.
grateful.
13.
14.
Grateful.
Lordship, I am for the state.
14, my lord, I'm praying for only one day accommodation, my lord. Only one day accommodation, my lord, I'm praying for.
No, not today.
Grateful.
15. I am for the state.
Who is for the petitioner?
Mr. Shahjahan Ali is appearing for the petitioner. He is requested to pray for adjournment, my lord, for this. Only
Why?
not. Yes. He is ill, that's why he's not
He's-
come to the court, my lord.
All right, 7th. 7th.
16.
I appear for this. I do not know what my land friend will submit. Maharaj. This cannot be decided without affidavit, subject to what my land.
Yes, yes. My lord, the
Disciplinary
departmental proceeding was started. My lord, with a
Removal from service,
which was
compulsory retirement.
culminated with the order of punishment of compulsory retirement.
Yes.
Thereafter, he preferred an appeal and the division which was rejected. Sure, the matter should be heard on merit after.
Can you just take me to the order of punishment?
My lord,
Can you please take me to the order of punishment?
Punishment order দেখাতে বলছেন দর্শক।
punishment order.
তার জজ সাহেব দেখাতে বলছেন।
Yes, yes. Lordship, can you come to
P5.
145, page 145, P7.
No. 135.
45.
145 or 35?
No, 145.
45 is a middle portion.
Notifying of the order of the disciplinary authority.
Serious allegations, my lord.
I have read that. Impersonating wife's signature.
Proved before the forensic authority.
All right. Ash- The petitioner was an assistant sub-inspector with the Railway Protection Force, within bracket RPF, bracket closed. The petitioner was charge sheeted on March 25, 2021. Full stop. An order of penalty was passed on June 25, 2022 by the Divisional Security Commissioner, RPF, stroke, the disciplinary authority, whereby the petitioner was compulsorily retired, compulsorily retired from service, full stop. Such order of penalty was challenged before the appellate authority, full stop. The appellate authority dismissed the appeal on October 12, 2022, full stop. The revisional authority dismissed the review petition on May 24, 2023, full stop. Mr. Mojumdar, learned counsel, appearing on behalf of the petitioner, challenges the memorandum of charge, findings of the inquiry officer, order of penalty, order of the appellate authority, and order of the revisional authority in the present writ petition. Full stop. Next. Learned counsel appears on behalf of the Union of India and submits that there is no scope for passing of any interim order in the present writ petition. Full stop. Next. Accordingly, the respondents are directed to file an affidavit in opposition within 6 weeks from date, full stop.
Your lordship.
Reply, if any, within 3 weeks thereafter, full stop. Next. Parties will be at liberty to mention the matter for hearing, bolded, upon completion of the period stipulated for exchange of affidavits, full stop. Server copy.
Opposition by
6 weeks.
Yes. Grateful to.
17. Item number 17.
YOLO. Monthly list of September.
18.
I'm mapping for the petitioner.
I will prepare on behalf of WBSCDC.
But this is my affidavit of service, Millard. I've sent the notice of my message.
Yes,
This is matter about Millard compassionate appointment and other benefit. Millard,
your father died,
no lords.
Mother,
mother, when?
Millard father died
5th of May 2021.
Millard,
Before my learned senior friend starts, my lord, may I submit, my lord, we have already given a notice, my lord, stating that the husband of the deceased has given us a letter along with a certificate of marriage, my lord. Having knowledge of that, my lord, he is not being made a party to this proceeding.
Millard, as per Millard memo,
Submit once more.
The husband,
Husband of the deceased has already died.
no, he is the second husband.
All right.
Has already given us a letter, my lord, submitting the marriage certificate.
Millard,
Yes.
we are
My lord,
saying
we have already intimated them, my lord, but the husband is not being made a party to this proceeding.
But he's praying for compassionate appointment.
Yes, the husband is less than 40 years of age.
Millard, they are claiming Millard, his husband Millard. Millard, I am not know Millard whether he's Millard. Millard petitioner has no knowledge Millard, his mother second time married.
Is his name included in the service records of the deceased employee?
My lord.
I'm very sorry. This is not the time to mention.
Item number 19.
My lord, item number 19, my lord, Ms. Sushmita Shah.
I'm for the
But I
I'm for the private respondent.
Well, I am for the provision for.
But I appeal of the petitioner, my lord. My lord, cutting the matter short, my lord, I was not given my pensional benefit, my lord. But after the filing of the writ petition, my lord, my employee, my lord, the respondent number 5, my lord, have my lord issued a my lord letter seeking the documents, my lord. And my lord, the documents were duly submitted, my lord. Today, my lord, perhaps they will receive the documents also. So, my lord, I am praying, my lord, if the matter can be stand over for the month, my lord, if in between that time, my lord, if I will get my benefit, pensional benefit, my lord, the writ petition.
My
my
lord,
lord.
it is, the money is with Regional Provision Fund Commissioner Bangalore, my lord.
Yes, my lord, they made a party, my lord. I have made them a party, my lord.
My lord, they will give the pension.
Yes, my lord. My lord, the scheme certificate,
And
my
as
lord,
such,
at
my lord,
page
this writ
29,
petition is
my
not
lord.
maintainable here, my lord. This writ petition is not maintainable here.
Let
He-
the partly
the
part
em-
cause of
employer
action
is-
rise over here, my
The
lord. That's why I have made
the office of the employer is at Bangalore. They have deposited the amount in Regional Provision Fund Commissioner Bangalore.
Anyway, he's praying for an adjournment. Let me adjourn it till the monthly list of September. Mrs. Banerjee, in one of the matters, hearing matters, I have been calling on you are there. So kindly check the list. It is just monthly list of September. করে রেখা। It is submitted on behalf of the petitioner that the issues raised in the writ petition may be let
My lord, the affidavit of service, my lord, be kept on record. My lord, all the parties are appearing, my lord. My lord,
Item number 20.
For the petition. In this matter, my lord, we have participated the examination of CAPF.
Union of India.
My lord, thereafter we passed the written examination. Subsequently, thereafter, the respondent authority called for us for PST and PET. We have duly participated and passed the examination. Thereafter, on 25th May, the respondent authority again issued notification cancelling the earlier, my lord, the PST and PET, and fresh notification. In this, similar order has been passed in this matter. Yes, 17 July. My lord, I have that copy. Instant.
Lordship, here we had prayed for instructions, Lordship. My instructions are in these matters, Lordship. What had happened was, this is purely an internal matter. We had received a complaint that extra time was awarded to the candidates. And we had inquired into the matter and we had to change the entire board of officers conducting the examinations. Therefore, the examinations held from
Yes, I have paid. It is updated and it is shown because I.
Yes. What has happened is that they have to be given 2 weeks notice. No, Lordship. That guideline was produced by him. You please look at that guideline. That is why this order was passed.
That is for downloading the.
Please show it to her. I don't think you have annexed it.
Yes.
No, it's not annexed. It is not annexed. It's not annexed. Let's see.
12 points.
Lordship,
2 weeks before.
2
the
weeks
conduct.
before the test concerned.
That is the
Lordship-
reason why I have passed this order. Because
I'll just check on that because Lordship, they had.
that is why I
already-
have said
they
take
have al-
necessary instructions and come back.
I'll just get a.
That is the issue, because if
specific
there is a
instructions.
loophole on your part, they will necessarily harp upon
Yes,
that.
because we had, yeah, definitely. But because they had
Maybe you
partic-
have conducted it in accordance with law,
Now-
there was a requirement for you to conduct. This court is absolutely with you, but then if there is any
I'll
infirmity.
just check on that. I'll just check on that, Lordship, will kindly give me time. ঠিক আছে, একটু ওটা রিপোর্টে ঢুকিয়ে ওটা করতে হবে। Report-এ-
আসুন।
Page 20.
So the first PAT in all the cases were held in May 2023 and the second in June 2023.
Yes, yes.
All.
yes. Oh, yes.
In all the cases. এখানে
Page 20 is the
পান্ডের জায়গায়
first-
Mrs. Alam করে দিন।
First.
I'll let the matter appear for further consideration under the heading motion on September 4, 2023. Motion on September 4.
আর এটা আবার তার এটা আবার সেটা
Oblige your lordship.
সেটা নিয়ে Let- yes, Lordship, Lordship. এটা আমি রাখি Thank you.
21 I for the petitioner, my affidavit of service. Union of India. My lord, petitioner, this is a totally, my lord, mercy application before your lordship, my lord. Because, my lord, why, my lord, there is no any rule, my lord, to grant some benefit in favor of the petitioner. But, my lord, that this is totally, my lord, once my lord, petitioner was appointed as, my lord, the airman, my lord, in the Indian Air Force, my lord, in the year 1982. In the year 1985, my lord, petitioner, my lord, submitted the resignation letter because, my lord, due to the family problem, my lord, he is not continuing because, my lord, he was posted in, my lord, the posted Bangalore, my lord, posted in Bangalore. So, my lord, due to his family problem, he submitted a resignation. In the letter, my lord, in the certificate issued by the authority, my lord, there is some written notes, my lord, because, my lord, the unlikely to make an insufficient workman in the said certificate. So, my lord, during his lifetime, my lord, he was not get any job, my lord, on the basis of this certificate, my lord. So, my lord, he submitted an application to give some, my lord, he has completed from 82 to 85, my lord, he worked his job, my lord, only for the pension, my lord, so, my lord, applied, my lord.
What is this? What do you take the court to be?
I submit first, you know, this is a
What
mercy.
is this?
Well, see, he made a representation that was turned down, my lord.
Naturally.
Yes, my lord. I, well,
What
only
do you
basis
take
of
the
this
court to
certificate,
be?
only basis of the, he has not.
It should be dismissed with costs so that these kind of litigants do not come to court.
Firstly, I submit before
No,
your
it should
lordship,
be
this is a
dismissed
mercy
with costs.
application, my lord.
For wasting judicial time, this should be dismissed with costs.
Firstly, I submit before your lordship, this is.
May I
mercy
submit one
application
thing?
before-
If you also can see paragraph 7, my lord.
You want costs?
No, I am not
Then-
for court. Because he has already approached this honorable court and my lord, writ application has been dismissed in 2008.
The petitioner was posted as an airman in the Indian Air Force on November 29, 1982. Full stop. The petitioner was discharged from service on February 2, 1985. full stop. The discharge certificate records that the petitioner has been discharged in accordance with rule take capital R 15 within bracket J bracket closed of the Air Force rules 1969, comma, as he is unlikely to make an efficient officer, full stop. The petitioner has now prayed for his retirement benefits. Full stop. Next. Mr. Mondal, learned counsel appearing on behalf of the petitioner, submits that since there was the aforesaid remark in the said discharge certificate, the petitioner was unable to get a job elsewhere, and therefore the petitioner's prayer for pensionary benefits should be considered sympathetically, full stop. Next. Mr. Ghosh, learned counsel appearing on behalf of the respondents, submits that no part of cause of action has arisen within the territorial jurisdiction of this honorable court, full stop. The same has been recorded by an order passed by a coordinate bench on June 16, 2009 in WP number 28829 within bracket W of 2008, full stop. The petitioner has again sought to agitate the grievances before this honorable court, full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that the writ petition is barred by inordinate delay, full stop. The writ petitioner was discharged from service on February 2, 1985, full stop. The writ petitioner has sought to challenge the said order of discharge by filing a writ petition on July 12, 2023, full stop. Next. Since this court is of the view that the inordinate delay on the part of the writ petition disentitles him from claiming a discretionary remedy, comma, this court has not gone into the issue of territorial jurisdiction, full stop. Next. A beneficial reference may be made. বলে আমি একটা decision দিয়ে দেবো apex court এর। comma, full stop, next. Accordingly, comma, WPA 164858 of 2023 bolded is disposed of bolded. Since no directions for affidavits, with the next hocche. Server copy, certified copy.
Good.
Mr. Mondol, why did you advise your client to file this? Unnecessary waste.
It's also
of
about
time.
the AFT matter, my lord, Armed Forces Tribunal matter, my lord, Navy and Air Force. And
Anyway, inordinate delay.
very well, my lord. That's why-
Otherwise,
that's
alternative
why I am not
remedy,
telling anything.
natural justice.
Yes, yes. That's
All
why
that
I-
has to be gone into whether
that's why-
he is in probation or not,
Yes.
discharge, simpliciter or not, all that I have to say.
That's why I am not saying all this thing.
No point.
22. Item number 22.
My lord, I am for the petitioner, man.
I am appearing for
My
the
lord.
state.
The matter is, my lord, petitioner prays for, my lord, voluntary retirement. He made an application before the authority. My lord, authority did not consider the application. The petitioner came before this court. If your lordship kindly come to page 43, your lordship pass an order by directing them to consider after constituting a medical board. Because, my lord, voluntary retirement was prayed for his health issue.
Medical grounds.
Medical grounds. My lord, medical board was constituted. My lord, thereafter final order was passed, page 48. It starts from 47, page 48.
Yes.
My lord, first, second, third. My lord, fourth paragraph. My lord, complying the order of the writ petition and Home Guard 1718 Viku Mondol was placed before the medical board constituted by the medical superintendent cum vice president Malda Medical College and Hospital, Malda on 19th May 2023, where 6 medical officers, associate professors and MSVP Malda Medical College and Hospital were member, and after due deliberation, the said medical board declared the writ petitioner and the Home Guard such and such declared in the writ petition and Home Guard Viku Mondol medically fit. My lord, my instruction is, my lord, Viku Mondol was petitioner was called for before the medical board, but no test has been done. No, my lord, medical examination has been done. My
So
lord,
now the court will go and medically examine
my
him?
lord, I pray for the report of medical reports. My lord, kindly come to page 18 and 19 once of my pleadings. Paragraph 18 and 19.
6-member board has been constituted,
But
still you are not
without
happy.
any test, my lord. In the earlier, in
Absolutely vague allegation.
You have the instructions with you?
Yes, yes.
Yes, give.
The last page of my instruction, that kindly go through, lordship. The allegation that the medical board did not examine him properly is baseless and wild. The allegations of misbehaving and using filthy languages against the writ petitioner is also blatant lies. The opinion of the medical board as well as the reasoned order of the competent authority regarding his voluntary retirement and employment of his dependent.
So you produce the medical report?
Yes. 6 members medical board report.
Yes.
Opined that he is medically fit.
Ashu.
my lord, may I get the copies of the?
No. This is not for you.
No, report, my lord, first.
The medical report? No. By an order dated March 20, 2023, passed in WPA 3784 of 2023. this court directed the consideration of the representation of the petitioner dated December 31, 2022 by the Superintendent of Police, Malda, upon medical examination by the board constituted by but by the full stop. The Superintendent of Police, was directed to pass a reasoned order. Full stop. A reasoned order was passed by SP, Malda on May 25, 2023. Full stop. Such reasoned order is impugned in the present writ petition. Full stop. Next. From the reasoned order, it appears that the petitioner was examined by a medical board constituted by the medical superintendent -- vice principal, Malda Medical College and Hospital on May
19th.
19, 2023. Full stop. The said medical board was comprised of 6 medical officers, associate professors, and the MSVP. Full stop. After due deliberations and assessing the physical condition of the petitioner, the medical board declared him fit, bold, inverted commas, and communicated their findings to the SP on May 24, 2023. Full stop. Therefore, the SP, by the impugned order dated May 25, 2023, rejected the prayer of the petitioner for voluntary retirement. Full stop. Voluntary retirement, full stop. Since the petitioner was medically fit, bold, and capable of performing his duties. Full stop. Next. Learned counsel appearing on behalf of the petitioner submits that no tests were conducted upon him by the medical board. Full stop. Next. Learned counsel appearing on behalf of the state respondents hands over the written instructions in court today, along with the opinion of the medical board. Full stop. Such written instructions, along with the report, are retained with the records. Full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court is of the view that there is no infirmity in the decision-making process of the impugned order dated May 25, 2023, full stop. The SP has given reasons for non-consideration of the application for voluntary retirement of the petitioner, relying upon a medical report of a 6-member board constituted at the Malda Medical College and Hospital, Malda, full stop. Next. Accordingly, WPA 16465 of 2023 bolded is dismissed bolded, full stop. Since no directions for affidavits, next one, server copy, certified copy.
We are to
23.
My lord, I am led by Mr. Subhamoy Patra, behalf of the petitioner. I am appearing not today, my lord.
Lordship, this matter is not maintainable, this writ petition.
Let them come. Without their presence.
He
how
is
can it-
suffering from fever, my lord.
What?
He is suffering from fever.
21st August.
Bibliography.
24.
Lordship, I am for the petitioner, Lordship. Lordship, affidavit of service is ready. Lordship, the sum and substance of the matter is, Lordship, your petitioner is entitled to employment under the land loser scheme in the ACL, Lordship. His name appeared in the company's website, Lordship, as an entitled to employment, Lordship. Kindly see page 35, Lordship. P11 annexure, Lordship. And thereafter, Lordship, his name was also referred for medical examination. Lordship, kindly see, Lordship, page 33, P9 annexure. And Lordship, as well as Lordship, his name was also referred for police verification, Lordship. Page 32, P8, Lordship. Lordship, they have started the due diligence, but Lordship, the letter of appointment was not confirmed, Lordship, till date, Lordship. The ECL has acquired the land, Lordship, the family's land, Lordship. This is my grievance, Lordship.
Yes.
My lord, four defense, my lord. First, my lord, is my lord, delay, my lord. Kindly see last, my lord, annex, my lord, whatever has happened, my lord. Kindly see PP5, my lord, whatever has happened in 2012. Thereafter, my lord, a representation has been given in 2023. In between, there is nothing, my lord, no explanation why this delay, and nothing has been given, my lord. That is my primary objection, my lord.
Yes.
Now, second objection, my lord, is, my lord, that, my lord, no patta certificate was given to us, my lord. Your lordship knows, my lord, like a sale deed, my lord, we have to give sale deed, my lord, to show that the land belongs to us, my lord. If a person is obtaining a patta, my lord, they have to give patta certificate. It was not given to us, my lord. Now, my lord, that
Where
patta
do you say that?
Now, my lord, this, my lord, patta certificate, they themselves have said, my lord, and they said that it is missing.
Where?
My lord, they have annexed 3 diaries, my lord. My lord, your lordship will find, my lord, patta certificate, police verification, complaint, police loss complaint, page P4, my lord. P4, my lord, your lordship will find, my lord, they have annexed, my lord, their case is that it has been lost. Now, most importantly, my lord, I will come to that also, my lord. This certificate, my lord, while it has been issued, my lord, one has to sign, my lord. This petitioner, my lord, admittedly at that point of time was 2 years, my lord. Just 2 years. Now, my question is to you, to myself, my lord, whether patta can be given to a minor, my lord. My third point is, my lord, whether a patta can be given to a minor. This we have specifically asked, my lord, the PLRO, my lord, kindly comes to my lord, page 34. Page 34, my lord. Kindly sees, my lord. This is to inform you that the, have you lordship got, my lord, page 34. This is to inform you that the claim has been received to this employment of patta land of plot number 756 from Moja HON'BLE from Samrat Roy of such and such. As a record received from your office, Samrat Roy has been allotted patta vice RS that number 3 of 93. Kindly mark 3 of 93. Serial number 196 and area is 75 acres against the plot number 756. Moja HON'BLE. The date of birth of Samrat Roy is 31/7/91. This is admitted by the my lord. Therefore, the time of issuance of patta, Samrat Roy, his age was 2 years. You are requested to kindly confirm this office whether any of such, whether there is any bar of age limit for issuing of patta of minor. But
Yes, then what happened?
No reply given, my lord, by the BLRO. But here, my lord, they have not made state of West Bengal a party or a BLRO party, my lord.
I will give them leave.
Lordship, to his
another point, my
Lordship, I'll reply to his contents.
Another point, I have not finished, my lord. Now, my lord, kindly see, my lord, I will just hand over, my lord, your lordship, my lord, the police verification report. I'm giving copy to him, my lord. My police verification, my lord, it clearly says, my lord, that this person, my lord, are residents of Saitya, ward number 15, PS Saitya, Birbhum, district Birbhum.
Yes.
Now, my lord, in there, my lord, the next page, if your lordship sees, my lord, this is the attestation form. There also, they have mentioned the same address, my lord, Saitya. It is their document, my lord. Next page, my lord, Saitya. Now, my lord, the Saitya, last page, my lord, the next one, my lord. Just next document, my lord, after the police verification, next document, attestation form, my lord, which they have submitted to us, my lord.
Yes, Saithya Purvopolli.
Saithya, my lord.
Yes.
Thereafter, my lord, last annexure, my lord, your lordship see, my lord, the Saithya municipality had also issued, my lord, a certificate that this Samrat Roy, he is, my lord, the permanent residence of Saithya, my lord. Ward number 15 of municipality for district Birbhum.
Yes.
Now, my lord, land has been given to them, my lord. In my lord, Andal, my lord. Andal is, my lord, Bardhaman.
Yes.
Paschim Bardhaman. Now, if your lordship take up, my lord, the section, my lord, 47, my lord, for once, my lord. Kindly, my lord, take up 47, my lord. 49, my lord. 49 of Land Reform Act, my lord. If I may place, my lord. 49(1), my lord. Notwithstanding anything contains as well this act or in any other law for the time being in force, settlement of land which is at the disposal of the state government shall be made without any premium being charged for it in such a manner as may be prescribed, which person who are residents of the locality, locality where the land is situated, and who together with others members of the family own no land or less than 4.4047 hectares of land used for the purpose of agriculture. One half of the land cultivated by them as a bargadar being taken into account for the purpose of calculation of the aggregate of the said land and the subject of the following condition. We cover the first one, that in case of agricultural land, such person intend to bring land under personal cultivation. So, my lord, kindly see, my lord, the land, my lord, which is to be given, my lord, that has to be a locality land, where they normally reside, my lord. Birbhum is a different district, my lord, and Paschim Bardhaman is a different.
What happened during that time, we cannot be deciphered from your records because you have already considered this case. Today, you cannot take, even ECL cannot take such a point at a belated stage after considering him.
Lordship, I agree.
And he has gone up to the stage of medical examination.
Yes,
my lord, but my lord, this
you
point,
cannot take his land and then rely on these issues.
No, my lord, only what we are verifying is that, my lord, whether this person is patta holder or not, my lord, whether
That is a
that is
separate
legal or
issue.
not.
That is a separate issue.
Lordship,
I've written to the
My lord,
BLR.
that document is not
Lordship,
legal, my
his
lord.
name is in the LR record,
Exactly.
Lordship.
If
আপনি
the
বলুন,
line
বলবো
is
না,
not detailed, my lord, and if we don't make such inquiry, my lord, then my lord.
Yes, of
our
course, you will make the inquiry.
Yes, my lord.
But
Now the
you have
BLR,
to
my lord,
make
has
the
not
inquiry
replied to that,
before
my lord.
sending him for medical examination. You have made the inquiry,
But
Apo-
it's going simultaneously, my lord, medical examination and also this inquiry, my lord. Kindly see, everything is at 2012 and 2013.
Yes.
Kindly see, my lord. But we did not receive any reply, my lord, from the
Now
BLR.
in 2000, up to 2012, all these inquiries have taken place. In
After
2013,
2012, no, my lord.
you have raised this point before the BL and LRO, whether he could have been given the patta at the age of 2.
No reply has been come.
Yes. Now, an additional point you have, what has happened factually, I won't be able to tell you. Whether or not they were using it as an agricultural land, that I cannot tell you now. You have taken the land from him. You have considered him in the land losers category. He has gone up to the stage of medical examination.
Lordship,
And then you have
petitioners-
found that patta has been given when he was at the age of 2. You have asked for an inquiry from BL and LRO and you haven't taken any steps from 2013 and he has also not pursued his claim from 2013. This is the fact of the matter. Yes. What do you want to show?
Lordship, kindly sees the Lordship, what you have submitted, Lordship, the police verification report. The Lordship, there is nothing adverse on record against him in this district, Lordship. That is clear, Lordship.
Case.
And Lordship, kindly sees page 22, his name is recorded in the LR record, Lordship. And his mother also is a
That is the question about a minor man. How his name can be
other
recorded,
member
my
of
lord?
the family was also,
How can
Lordship,
it be
they have acquired the land of
contracted?
other members of the family. And Lordship, they are entitled to give one job to any member of the family when they acquire land, Lordship.
Yeah, my lord, BLR should be added, my lord, and a report
Yes,
may be
yes,
called
that
for,
will
my
be
lord.
done.
Okay, my lord.
That I have
Yes.
followed. That
That
be
will
done.
clear our conscience also, my lord, and your lordship direct us, my lord, will give him the employment, no problem. My lord. But that will clear everything, my lord.
Yes, yes. Ashu. The petitioner's case is that he is entitled to a job with the Eastern Coalfields Limited, within bracket ECL, in the land losers, এটাকে একটু italics এ করে দেবেন inverted commas এর মধ্যে category, full stop. The petitioner's name appeared in the records of the ECL. Full stop. Proposals for employment were considered for several persons, including the petitioner, in the land losers category, italics, in the company's website as on July 12, 2013. Full stop. Next, learned counsel appearing on behalf of the petitioner submits that by a document dated November 26, 2012, issued by the senior manager within bracket mining to the officer in charge, comma, Santhia Police Station, police verification of the identity of the person and antecedents of the petitioner were called for, comma, since ECL was in the process of considering the claim for employment of the petitioner, full stop. Next, from a document dated December 12, 2012, it appears that the petitioner was sent for initial medical examination, full stop. Next, Mr. Arifin, learned counsel appearing on behalf of the petitioner or on behalf of the ECL submits written instructions before this court, full stop. Such written instructions are retained with the records, full stop. From the written instructions, it appears that the SP, Birbhum, certified that the petitioner's identity was established beyond a doubt, and there is nothing adverse on record against him in the district of his residence, full stop. Next. However, he submits that it is doubted whether the petitioner could have been given patta in 1993 when the petitioner was only 2 years of age, full stop. Necessary communication was made by ECL to the BL and LRO, full stop. However, there is no response from BL and LRO till date, full stop. Also, despite being a necessary and proper party, the BL and LRO has not been made a party to the present writ proceedings, made a party, to the present writ proceedings, full stop. Next. He also submits that the writ petition is not maintainable since there is no communication between the parties from 2012 onwards, full stop. Therefore, the writ petition is barred by delay, acquiescence and laches on the part of the petitioner, full stop. Next. Considering the rival submissions of the parties and the materials placed on record, this court feels that justice will be subserved by directing the petitioner to make the BL and LRO a party to the present writ petition, full stop. Next. The learned advocate appearing on behalf of the petitioner is directed to make BL and LRO, Pandaveshwar,
Now, my lord, I
party
think, my lord,
respondent to the present proceedings, full stop. leave is granted to make necessary amendment to the cost title.
Now, my lord, I think my lord, this BL and LR of Pandaveshwar, my lord, it has been divided, become BL and LR of Ondal, my lord. My lord, if-
Pandaveshwar or
Ondal.
stroke Andal.
The present BL, my lord.
Next, let the matter appear for further consideration under the same heading motion bolded on August 17, 2023. Serve a copy. Bolded এটা করে দাও, ডেটটা আর motion.
25.
No, 25, I appear on behalf of the petitioner.
I beg to appear on behalf of the respondents.
No, this is service. The petitioner was a constable in CISF, joined in 1985. Some allegation has been brought against him, but he has been terminated. Challenging that, my lord, he preferred a writ petition before this Honorable Court. Now, this Honorable Court pleased to pass an order directing the authority to reconsider the punishment, because they have issued the punishment of termination, that's why. Now, they have considered the punishment and they have passed an order. That order dated 31st March 1997 at page 44. Now, challenging that, another writ petition has been filed before this Honorable Court.
Page 44.
44, this is the initial, that is the order, wherein the punishment has been imposed, lighter punishment has been imposed. Page 46 is the relevant portion. Page 46. Paragraph 5, the sub-paragraph, the punishment. May I place it, Lord? Lord, pay off number such and such, Constable SK Dev, be reduced to the lowest stage, that is from 900 to 855 in the time scale of pay of rupees 825 for the period of 2 years. This is the first punishment. Then, with effect from the date of the rejoining or reinstatement, it is further ordered that the Constable SK Dev will not earn increment of pay during the period of reduction, and that on the expiry of the said period, the reduction will have the effect of postponing his future increments of pay. But this is the punishment. Next, paragraph 7, my lord, can you see? He is reinstated in service. He is directed to report to the unit of his last position, that is CISF unit HOD Holdia, but within 15 days from the date of receipt of this order, failing which it will be presumed that he is no longer interested to rejoin and reinstatement, and further order will be the first accordingly. Page 47, paragraph 8. It is also proposed to treat the intervening period from the date of removal of service to the date of reinstatement as dash known, and not to pay him any pay and allowances for the said period. He is given an opportunity to submit his representations, if any, against the proposal within 15 days from the date of rejoining duty on reinstatement. Now, challenging this, Lord, again a writ petition has been filed before the Honorable Court. Page 53, this is the order passed by this Honorable Court. This is the order dated 1st of February 2006. The writ petitioners were charge sheeted.
That is all right. Just come to the operative portion
Yes,
at
yes.
54.
Not the
Hence the
page
order
fif-
of punishment.
Page 54. Not the second paragraph.
Yes, hence the order of punishment.
Hence the order of the punishment is modified to the extent that punishment awarded to the writ petitioner would not have any cumulative effect.
Yes.
Because my lordships kindly recollect, I have shown that the 3 increment has been reduced. Number 1. Second, my lord, no further increment for 2 years.
Yes, I
Third-
have seen that.
Yes. Then, my lord, this order has been challenged by the, my lord, the respondent authority before the Honorable Division Bench. Now, Honorable Division Bench, page 55, order dated, my lord, 9th of April 2019. Their appeal has been dismissed. Lordships, kindly come the operative portion, page 58. Lord, third paragraph. In that view of the matter, we have no hesitation to hold that learned judge was right in holding that the disciplinary authority did not have the power to impose the punishment what he did by his order dated 31st March 1997. I have shown. And to observe that the punishment will not have any cumulative effect. There is no merit in the appeal and the same stand dismissed. Next portion, last paragraph. If the is that since the in contempt petitions lot is been disposed of without passing any order, whatever the liberty, the petitioner is at liberty, last part 1 paragraph, page 59. The petitioner is at liberty to proceed in accordance with law if so advised. Because cumulative punishment has been given, that cumulative punishment should not have been given according to the Honorable Single Judge as well as the division bench. But they says in that, but even a discussion was also made in between the parties because when the contempt hearing was going on, the Honorable Division Bench in contempt proceeding says that what is the problem, you sit up. Now nothing has been done. A petition thereafter, after disposal of the contempt proceeding, a detailed representation has been made, page 61. What is the effect of imposing the cumulative punishment? Now, this is, I have elaborately discussed page 66 in my representations. Page 66, it starts from page 61. 66, I have specifically indicated Roman 1, 2, 3, 4, and by this way. Since they have imposed this punishment upon me, may I place it?
So they have not taken a decision.
Now, the commandant of the unit, page 74, he has simply sent the letter saying that very peculiar letter. I have never seen, no reason, nothing is there. This has been communicated. This is under challenge in the street petition. But these should have taken into consideration. I have specifically indicated one after another how I am affected. Since the division bench specifically directed that if any deprive has been made in terms of the order dated, that is the punishment on 31st of March 1997, that has to be restored to me.
No, that you have to seek clarification from the division bench's order. The single bench has only directed that the provision with regard to increment, the punishment with regard to cumulative effect is modified.
Should not be given.
The single bench, according to the mind of this court, did not touch the provision of diasnon.
Yes, that is there.
Do not try to take advantage.
Not only that,
this is not before this court, you will not be able to do that. If you have any problem, you have to go before the division bench, because the division bench was only clarifying the order of the single bench. It was not your appeal, neither have you filed a cross objection. It was an appeal by the authorities. There, the single bench's order was clarified. If you have any problem with the division bench's order, you have to file an application before the division bench.
No, not
This
kindly
way,
see-
you cannot ask for benefits from the single bench.
No, they are not kindly see. There are punishment which has been imposed, which is given effect, cumulative effect.
That
Number
I have
one,
understood. Now you are trying to, along with the punishment of cumulative effect, now you're trying to attach the punishment of diasnon as well.
together with,
Yes.
together with. I'm
That
not
you
saying
cannot
that.
do.
Yes. No, here, Lordships kindly see. What does division bench says? Division bench says the
What the division bench says, the division bench will clarify. It is not for the single bench to clarify.
I'm not asking for, I'm not praying for even.
Yes.
My submission is this. Since the division
I
bench
have understood your submission. I have read every page. I have understood your submission. What you are asking for is that the period of diasnon also should be considered.
that is another part, not the first part. 3 increment they have reduced.
Yes.
So if the 3 increment they have reduced, this will affect. the
Had you
entire
not
life of-
confused the two issues together, I could have applied my mind in a better way. Since you tried to club the two issues together, that is the problem I am facing.
No, look, here Lordships kindly see, number one, three increments has been reduced. Now, effect of reduction of
You file a report only on the issue of the increments, whether cumulative effect has been stopped or not. Only with regard to that part, please file a report.
My lord, I will, my lord, but most probably it has been clarified in 74. Still, I'll file.
No, it has not been. It's a very cryptic order.
But only one.
You are just saying that all the benefits have been given. You please give the calculation.
My lord.
You please give the calculation that you arrived at upon consideration of the order passed by the
This
coordinate bench
Yes,
on
my lord.
February 7, 2006, I think.
My lord, kindly reflect that in the order. My lord, I'll certainly, and my lord, give us some time so that calculation can be.
What is the date of the order at page 53,
Page
February 7,
53.
2006?
My lord,
I'll see. Page 53, that is 7th of February, probably 7th February 2006.
2005.
my lord, 7 February 2000.
2005, I got it from the division. No, I have got it from the division bench's order.
Order also speaks of it.
But
Ashun,
issue, if your lordship, only one submission I'm making.
The
Lordship-
petitioner prays for disbursal of his retirement benefits in terms of the order dated February 7,
No, retirement benefit not. The
service benefits in
Yes.
terms of the order dated February 7, 2005. Full stop.
No, Lord, this is not that. Lord,
The petitioners,
just Lord, the page 36, Lord, the order.
I have understood so much long I have given you. I have to say what I understand. The petitioner's grievance is that
Lordship, I'm for the petition, Lordship.
I'm for respondent number 6, my lord.
Mirodpal Chakraborty to? এটা কোনটা নাম কি? মিrodpal Chakraborty? হ্যাঁ। Whole ইয়ে নেই?
Here for CSTC?
Provident Fund.
Lordship, CSC.
Yes, Mr. Sen was to take necessary.
Yes, Lordship,
steps.
one thing, Lordship, Mr. Sen has given me the handed over their opposition to the supplementary affidavit, Lordship. And I'm supposed, I have received it on 28th, Lordship. I have supposed to give one exception to their affidavit, Lordship.
All right.
Lordship, actually, I have to sit with my client, Lordship. I have received it on 28th.
My lordship, we have not received this supplementary affidavit copy.
They were not present, Lordship. That is why I think
We have not responded number 6.
they were never present, Lordship. First time, Lordship, I have seen her.
All right, Ashu.
Lordship, within this week, Lordship, kindly, because he is not getting his pension, Lordship. Since
Time
1.5
to
years.
file exception to the report, exception. Reply to the supplementary affidavit. No, sorry. Time to file exception to the report. By the petitioner is extended till August 10, 2023, full stop. Let the matter come up for further consideration under the same heading motion bold on August 17, 2023. Bold.
Only thing, may I file this reply?
আচ্ছা একটা reply এটা প্রথমে filed on behalf of CSTC to the supplementary affidavit is retained with the records. Full stop.
Lordship, fixed on
17th.
March 17th. 17th. Numberটা নিয়ে নাও, phone number.
59, I am for the state, my lord. This is group 2 matter.
Lordship, Mr. Shukanto Ghosh is appearing for the
It is
petitioner.
a group 2 matter.
Yes.
You have wrongly filed under group 6.
59.
59, I have checked. This is file under the group 2.
1 minute, let him check.
Tondra.
Group 2 to school to DI এর উপর দিয়ে করে।
Let him come, let the petitioner come. 17th এ রেখে দিন।
নাম দিতে।
Let the petitioner.
60. 70.
60, I beg to appear on behalf of the petitioner, my lord. This is a case of a dock labor board, my lord, where the affidavit has been filed. Well, wherein, I find that now they have taken a
Yes, Mr.
stand.
Gupta is supposed to bring
Yes,
instructions.
taken a stand that CCS rule is not applicable. They have own rule, but no rule has been annexed. But I will show your lordship, my lord, one notification issued by the Ministry of Shipping. Well, they are under the control of the shipping, Ministry of Shipping, central government, my lord, wherein it appears from the order that the CCS rule 54 is applicable in case of the dock labor board employee. Here what happened? My father was an employee.
I know on the last occasion,
Yes.
I asked Mr. Gupta to produce necessary instructions. Yes.
The supplementary affidavit.
You have a copy?
Yes, Mel, I got it.
Let him place, then you reply.
I start from paragraph 6. Paragraph 6. Milord, your lordship's query on the last occasion was whether the central government pension rules apply to this
Yes.
organization. Milord, paragraph 6 at page 2 of my affidavit, that two such schemes are being administered by CDLB, namely Calcutta Dock Workers Regulation of Employment Scheme 1970 and the Calcutta Dock and Clerical Supervisory Workers Regulation of Employment Scheme 1970. Now, that the central government issued several orders, namely orders such and such 2005, 8, 11, regarding implementation of revised rates of pension and dearness relief under dock labor boards in India. By the government order dated 19/12/2005, the Undersecretary to the Government of India, Minister of Shipping, Road Transport, Highways, Department of Shipping has specifically made a provision that in the event of returns earned from pension funds falling short of the amount required to pay the defined benefit, as contained in the said government order dated 19/12/2005 to the retired employees, such defined benefits may undergo downward revision. Furthermore, the ministry letter dated 18/2/2011, while enhancing pension, the ministry specifically pointed out that the same should be implemented by Port Trust Board subject to affordability. Lord, I have annexed these two documents, my lord, which says that if your funds do not permit, you may make a downward revision, or even if the government enhances the pension, you may adopt it provided you can afford it, because no central fund will be provided. In 1953, dock labor had started. Now, my lord, our difficulties. Paragraph 8. In 1953, Calcutta Dock Labor Board had started functioning with 9,369 workers. By 1467, the strength of workers was 17,405. Thereafter, majority of the cargo handling operation of Kolkata Port, including Haldia, remained outside the functioning jurisdiction of CDLB. However, CDLB had to incur minimum guaranteed wages without utilizing its manpower, resulting in huge losses from 1978 onwards. The introduction of pension from 1972 for staff and in 1979 for registered workers led to further strain on the resources of CDLB. The board could not develop any reasonable corpus for payment of pension to its employees. No balance is available in the pension fund of the board. Further earning potential of CDLB is bleak. In the board, at present, there are 56 employees, which includes 38 workers, while the number of pensioners as on 1/5/2023 is 4,070. Then, paragraph 9, that the answering respondents state that the current revenue earning of the board is about ₹5 crore per month, and the board has to make payment of salary and wages, pension, and other administrative overhead expenses of ₹0.65 crore, ₹4 crore, and ₹0.25 crore per month, respectively, involving total payment of ₹4.90 crores. Due to financial constraint, board could not revise the pension as per the various wage revision committee reports in time, as well as could not extend updated dearness relief to the pensioners. At present, the backlog dearness relief is around 153%. That as per the provisions of dock labor workers, regulation of employment in applicability to Majority Port Act 1997, dock labor boards were to merge with their respective port trusts. 6 of the 7 dock labor boards, except CDLB, were merged with their respective port trusts without any financial support from the government. The merger of CDLB with Kolkata Port Trust could not be done on account of significant liabilities of CDLB and precarious financial condition of KOPT. Moreover, there are no prospects of income to CDLB after merger with KOPT, as the revenue stream of about 50 crores per annum of CDLB will also end post-merger. About 50 crores means they provide about 4 point some crores per month. That the answering respondents state that the board has been paying pension consistently as per rates prevailing at the time of retirement of the concerned employee, and also enhanced DR as and when the fund is available to board. Board had extended benefit of restoration of commutation of pension as per the board decision with a resolution number 9 dated 30/11/2016. Board had also allowed revision of pension as per Wage Revision Committee 98, 2007 and 2012 time to time as per affordability, but the arrear arising out of WRC and updated DR could not be paid due to inadequacy of pension fund. The arrear on account of revision of pension and backlog DR amounting to rupees 967.38 crore as on 31/3/2023 remains unpaid to various pensioners of board. The board had sought for financial support from the Government of India for the same, which has not yet materialized. That the answering respondents state that no step has been taken either by the central government or the Shama Prasad Mukherjee Port Trust, Kolkata, as yet for giving any pension assistance or for merger of CDLB with Shama Prasad Mukherjee Port Trust, Kolkata, as has been done in respect of other major ports in the country. The answering respondents state that several pensioners had also filed individual writ petitions before the Honorable High Court at Calcutta from time to time, on which orders were passed directing payment of enhanced amount, and similar order was passed by the Honorable Division Bench of this Honorable Court. Unfortunately, CDLB has no income or resource to comply with such directions. The CDLB does not have any properties or assets. Its office premises is owned by the Port Trust. Only the office furniture, accessories, and stationeries belong to CDLB, the sale of which cannot generate sufficient revenue to liquidate its liabilities. Winding up also will not provide any solution, as on the contrary it will lead to stoppage of salary and the pensionary benefits which are now being paid. The answering respondents state that in one content matter, being CPN number so and so, the Honorable Justice Sanjeev Banerjee, as his lordship then was, and the Honorable Justice Samapti Chatterjee passed an order on 7th April 2017, internally holding that in view of the non-payment of enhanced amount due to absence of any funds, it cannot be said that CDLB had committed willful violations of the court's orders, and as such they cannot be held guilty. Liberty was given to the concerned petitioners to approach the central government for redressal of their grievance. Similar order was passed by another division bench of this Honorable Court comprising Justice Sanjeev Banerjee and the Honorable Justice Kaushik Chando on 26 November 2019. I state and submit that the central government has filed one report in the form of affidavit by Secretary Ministry of Shipping stating the financial conditions of CDLB. I have annexed that affidavit. It is stated that CDLB is a non-aided autonomous statutory body framed under the Dock Workers Regulation and Employment Act 1948, and the Ministry of Ports, Shipping and Waterways, Government of India is passing through precarious financial conditions since 2001, and as such do not have sufficient income or resource to make payment of the entire amount payable to the pensioners, either at the time of the retirement or whenever there is an upward revision or revision order of wage revision committees. The payments arising out of the differences of WRCs have been made on availability of fund. Moreover, wage revision committees are constituted by the Government of India basically for their employees, and CDLB can only implement the orders of the WRCs as per its affordability, and clause incorporated by WRCs which included revision of salaries and wages of the existing employees and workers, and also pension of the petitioners cannot go beyond its affordability. CDLB has its own rules for pension and gratuity. This is what your lordships wanted to know. CDLB has its own rules for pension and gratuity, namely the Calcutta Dock Labour Board employs pension and gratuity rules which came into effect from 1/4/1972. VDA Board's resolution dated 23/11/71. As per this rule, retiring pension is payable as per SSR 1 of 2022 of Calcutta Dock Labour Board Service Rules 9. And now Service Rule 9 is quoted below. The retiring pension is granted to an employee entitled if he retires voluntarily or is made to retire by the board on completing a number of years of qualifying service or on reaching a particular age, and in the manner, namely by giving notice in writing for a specified period, etc., as prescribed by the board for such premature retirement with full retirement benefits. Then SSR has also been annexed. Pension rule has not been, the Central Civil Service pension rules has not been adopted by CDLB, and it has its own pension rules as stated above. This is the situation, prevailing in Calcutta Dock Labour Board, for which, it is not in a position to make any payment over and above what they have been doing. That is also, everywhere, you'll find that out of 5 crores of income, 4.9 crores, it goes out every month. Therefore, to make further payment, we are not, since we have not adopted the pension rules of the central government.
That is what I wanted to know, whether you have adopted the pension rules in total.
Exactly, yes. Now, my learned friend's case here is, for regarding a claim for pension in respect of particular categories, my lord, which is not applicable to me. My lord, if your lordship kindly takes up his writ petition, তুমি বসো না
Page,
my lord, I point out, my lord, on what fact he says. My lord, he says that Narayan Prasad Nandi
she's saying that she's a wholly dependent daughter of the deceased employee.
yes. Now, my lord, whether they are entitled, he's entitled to get pension.
And after the deceased employee died, his wife received, and then the wife, her mother, has died in 2021.
Yes.
But she's a wholly dependent daughter of the deceased employee, and that's why under the pension CCS pension rules, she is also entitled.
CCS pension rules, it is so, my lord, that his claim lies under CCS pension rules. But so far as, my lord, our rule is concerned, we have not adopted that.
Yes. Yes.
My lord.
Anything else?
My, yes, sir. Sir.
My lord, my lord, if your lordship takes my affidavit in opposition, page 7 of this affidavit in opposition.
Yes.
My lord, kindly see the heading, item number 8. Subject is payment of family pension to unmarried dependent daughters of deceased pensioners. Or deceased, the above matter was raised in the last meeting of the board held on 3/11/2014. An extract from the minutes of said meeting is quoted below. Sri Amitav Banerjji, Labour member, stated that as per wage settlement and ministry's order, unmarried dependent daughters of the deceased pensioners were eligible to get family pension. But two cases, Sri Radharani Bashak, daughter of such and such, and Ajija Khatun, daughter of so and so, who were not only unmarried and dependent daughters of the late pensioners, but also physically handicapped, were debarred from such family pension. He requested to consider all such cases for family pension as per rules. Chairman stated that Chief Accounts Officer would examine the matter and place the factual position for consideration in the next meeting of the board. Chief Accounts Officer has submitted the following report in the matter. On examination, this is observed that the unmarried dependent daughters of the deceased pensioners are eligible to get family pension in category 2 as per provisions of WRC 2007 as enclosed on page 62. As per WRC 2007, the category 2 comprising unmarried or widowed divorced daughters and parent as applicable has been brought under the purview of family pension with effect from 1/1/2007. Board has not yet implemented this category in the sphere of CDLB till date in absence of affordability. Board is presently disbursing family pension to the incumbents under category 1 as per the said WRC 2007 as follows. Category 2 we have not implemented. Now, A, widow or widower up to date of death or remarriage, whichever is earlier. Then B, sons, daughters, including widow daughter, up to the date of his or her marriage or remarriage, or the date of he or she starts earning, or till 25 years of age, whichever is earlier. We are, for them, we are paying pension. In the board meeting, two cases, that is Srimati Radharani Bashak and Aziza Khatun, had been referred to not only being unmarried and dependent daughters of the deceased pensioners, but they are also physically handicapped as per records. At this stage, board had allowed the family pension benefit to Srimati Radharani Bashak up to the age of 25 years. On discontinuation of the same, Sri Kartik Chandra Bashak, brother of Srimati Radharani Bashak, has also made an appeal before the Human Rights Commission for allowing family pension in the matter of.
Yes, you have considered for the category where they are also disabled, suffering from disorder of mind.
Yes,
not only dependent, but
also suffering
disorder
from
of mind.
handicap.
For that category, you have adopted.
Yes.
But you have not adopted for dependents who are only in the category of unmarried or widowed daughters.
Depend. because we have category one only we are following.
Yes, this was pointed out on the previous occasion.
And now, but your lordship's specific query was whether we have adopted the pension rules. If we did, then all the consequences would follow. But we are not in a position to do that. We would love to do it, but then our funds do not permit that.
Yes.
My respectful submission, my lord, with regard to the affidavit filed by my learned friend, my lord, wherein what have they stated in the paragraph, all confined to, my lord, only enhancement of pension and enhancement of salary, not disbursement of any pension, my lord. Rather, my lord, the Ministry of, my lord, Shipping, recently, that is, my lord, February 2020, instructed all the boards and port trust to follow the Rule 54 of the CCS rule with regard to family pension, that is the divorce, my lord, daughter. I am handing over the, my lord, copy of the, my lord, order, my lord. That's why, my lord, last occasion, my lord, I implemented the Ministry of Finance, my lord, Government of India party, and Mr. Bhattacharya is appearing. Sir, আপনাকে একটা দিচ্ছি আমি। This is my Government of India, Ministry of Shipping, to all the chairperson, all major port trust. Second one, the chairman, Calcutta Dock Labor Board. Relevant portion is, my lord, page 5, family pension. Page number, my lord, written in bottom. Family pension. For the purpose of grant of family pension, the family shall categorize as under category 1 and category 2. Category 2, my lord, unmarried, and, my lord, divorced daughter not covered by the category 1. আমার কাছে আর নেই গো, তোমার পরে দিচ্ছি আমি। রাত্রি 12:30 পেয়েছি এটা, কি করে দেব তোমার? And also they have stated, next page, serial number 8.3, for the purpose of family pension, enhanced family pension, the rule position as per Rule 54 of the CCS Pension Rules 1972 would be applicable, because Rule 54, my lord, speaks for, my lord, family pension for divorced daughter. This order issued by the, my lord, Ministry of Shipping. They brought it, my lord, by this order and calculated to all the port trust, major port trust, and also Calcutta Lock Dock. Calcutta, my lord, Dock Labor Board. Another matter, my lord, which, my lord, came for hearing before the Justice Topinchen, as the lordship, my lord, taking the service matter, wherein it also, my lord, stated that we have own rule, but they did not produce it till date. Till date, no rule was produced, my lord, before this court. But this order, my lord, indicates that, my lord, Rule 54 of the, my lord, CCS rule will be applicable in respect of, my lord, family pension to the, my lord, divorced daughter. Here, in the writ petition, my lord, we have claimed for disbursement of pension in respect of, my lord, divorce category. That is category 2, my lord. This is not a case of an enhancement of pension. Because the board is guided by the Ministry of Shipping. Time to time, my lord, the Ministry
Yes.
of Shipping, my lord, circulated.
They have
order.
annexed 2 orders of the Ministry of Shipping. You are
That
you have
earlier order,
produced-
2015.
You have produced the 2020
The latest
order.
order, latest order.
Yes. Mr. Gupta, why was
I
this not
handed over
produced?
also, my lord, the order.
Why was not, why this order was not produced with your supplementary
In my
affidavit?
supplementary affidavit, if your lordship kindly takes that,
Ministry of Shipping's 2 orders were produced of
those 2
2011.
orders were produced, but I have mentioned, my lord, in my affidavit in opposition.
Because it will definitely not give a complete picture. This 2011 orders will definitely not give a complete picture.
Yes, no, I have mentioned, my lord.
You may have mentioned, but in the supplementary affidavit, I would have proceeded on a completely wrong basis if I would have relied on these orders.
No,
Yesterday, well, at 12:30, I got it from the internet. একটা কপি করুন আমার কাছে কপি নেই
This is a statutory body. This is an autonomous body filing a supplementary affidavit.
no, it was not brought to my notice.
This is very unfortunate.
We have referred, my lord, to two.
This is
things.
very unfortunate.
No,
Because you placed your submission on
there is-
on this on clause 5, drawing the attention of the court to the affordability. Whereas in the 2022 order, or
Right.
whatever you call it, communication, there is no clause corresponding to that clause. After 8.3, there is no such corresponding clause.
আপনি instruction দিন
No, in my affidavit, my lord, there is no reference to it at all. We have referred to, my lord, resolutions up to 2015. Nothing beyond that.
That is what I'm saying,
Yes,
because this
right.
clause with regard to the affordability is not there in the present one.
No, that is true.
This entire order would have proceeded on this basis.
True, my lord. That ought to have been included. Of course, my lord. There's no question about it. I
But
do
your
not know,
submission was
my
on
lord.
that basis.
Exactly, because that is my instruction. I made this entire submission on the basis of the instruction that I have obtained. This 2020, I do not know how they missed it. In any event, my lord, may I submit this? My lord, government directives are issued, and I am, I proceed on the basis that I am bound to comply with it. I don't have any financial support to comply.
Yes, that is a different thing.
I haven't got it. My funds will never permit it.
That is all right, but the order of the court has to be on the basis
That, my lord,
of the
I
legal
am not, my
principles.
lord, trying to explain that away in any way. That ought to have been included. No question about it.
So to the mind of this court, the suppression is deliberate, because I shall not be swayed by this statement that someone who is working with the port trust authorities is unaware of the latest circular or notification of the Ministry of Shipping. So this court will be constrained to hold that this is
Well, possibly not,
deliberate.
because your lordship has seen, my lord, only 34 employees managing the entire
This
asset.
court will be otherwise, what kind of work is he doing? He is drawing salary out of public money. What
True,
kind
but
of
then-
work is he doing that he is unaware of
What
a
they do,
certificate,
Lord,
circular of 2020?
my lord, the work they do is preparing, my lord, pension papers for 4,000 employees. Basically, my lord, that is the
He
job.
is drawing public salary, and this has not been brought to the notice of the court.
No, that ought to have been done. No question
And
about
this is
it.
an
my lord.
affidavit.
But it may not be deliberate. That's what I submit. It may not be deliberate, because, my
In
lord,
the mind of this court, this is deliberate.
kindly do not take it that way, my lord. Kindly do not take it that way. Your lordship will kindly excuse my client for that, because there may be situation, my lord, in which
He is the secretary. And he is acquainted with the facts and circumstances of the case.
yes.
And the relevant memo is not annexed.
No question about it. It ought to have been annexed. I do not know how they had missed it.
Deliberately missed it.
Perhaps not. because I always make queries to all.
We are in 2023 and this is a memo of 2020. After 3 years, he is not aware. So what kind of public service is he doing? Yes,
But your lordship will kindly do not draw that inference. Lord.
it appears to this court.
No, my lord,
Yes.
normally so, my lord, but the constraints with which they work, my lord, they have been preparing all through their main job.
I will give you another opportunity. You will bring on record why this memo was not.
Kindly do that.
I will give you another
Kindly do that.
opportunity. Let him
Let-
submit on affidavit why he chose not to bring this on record.
Kindly be compassionate.
To the mind of the, I was with you all this while, but till just now, this memo has been
No,
shown to me.
but then my lord, I am not giving any explanation for that, but kindly do not make any observation. Because there is a failure on my part also. I ought to have inquired whether subsequent to this there has
No. Supplementary affidavit has been filed and you are submitting on the basis of that. The instructions have to come from your client. You are not supposed to look up the internet to find all the memos of the Ministry of Shipping. The authorities who are in the know-how, they have to supply it to you. Have you or have you not issued this memo? Tell me first. Have you or have you not issued this 2020 memo? But that's enough. Rest I have read.
They must have issued it. No, they must have issued it.
Yes, he's saying yes.
He's nodding his head. I couldn't see him. He's nodding his head only.
This way. Which community? That is the question.
Ki nahi. Na.
You have to submit anything else? All right.
This 2020 circular also says. 2020 circular also says that central government will not bear any risk.
Yes.
But your lordship, kindly do not.
They will file another affidavit explaining why.
My lord,
The-
bring it on record. Kindly, my lord.
No, Mr. Gupta. No. The court cannot show compassion in this kind of cases. Supplementary affidavit filed on behalf of Calcutta Dock Labor Board is retained with the records. Full stop. Next. Mr. Gupta, learned senior counsel, appears on behalf of CDLB and refers to two memorandums passed by the Undersecretary, Ministry of Shipping, to a memorandum dated February 18, 2011, full stop. Refers to a memo for them. From the said memo, it appears that the port trust boards should consider the guidelines for revision of pension of the retired officers subject to affordability by the board. Full stop. For dependents being eligible for family pension, categories have been mentioned. Full stop. It has been stated that the additional expenditure involved for implementation of the orders will be met by the port trusts from its own resources, and no budgetary support will be provided by the central government for the same. From the second memo, dated February 18, 2011, issued by the Undersecretary, Ministry of Shipping, to the chairman of all the major port trusts and chairman CDLB, it appears that family pension to unmarried, widowed, divorced daughters in category 2 shall be payable only after the eligible family members in category 1 cease to be eligible to receive family pension, and there is no disabled child to receive the same. However, the payment of such family pension in the memo dated February 18, 2011, VDA number 29018/2006-PE-1 was not subject to any affordability by the port trusts. Full stop.
May I point out one thing, Lord? Kindly read paragraph 9 of this.
Port trust
Paragraph 9, Lord,
Yes,
places.
you read page 14, I am reading that. Port
No.
trust CDLB.
That is all right. But in this 2020, they have submitted before your lordship from the website that paragraph 9 of that, the liability is to be borne by the port trust, not by CDLB.
Next.
Paragraph 9.
From the said, next. It is submitted on behalf of CDLB that due to extreme financial constraints, the recommendations of the central government for payment of family pension as per Rule 54 of the CCS within bracket pension rules, 1972 could not be made applicable to the dependents of the employees of the board. Full stop. Next. Dependents of the erstwhile employees of the board. Beta capital. Full stop. Next. Mr. Das, learned counsel, appearing on behalf of the petitioner, hands over a memo dated February 5, 2020, issued by the Undersecretary, Ministry of Shipping, Government of India, dated February 5, 2020. Full stop. From clause 8.3 of the said memo, it appears that family pension / enhanced family pension is payable as per Rule 54 of the CCS within bracket pension bracket closed rules, comma, 1972. Full stop. This court finds no clause in respect of applicability of the said rule to the major port trusts and CDLB. Full stop. However, from clause 9.0, it appears that the additional expenditure would be met by the port trusts from its own resources and not by the central government. Full stop. Next. This court finds it perplexing that the memo dated February 5, 2020 was not brought on record in the supplementary affidavit affirmed by the Secretary, CDLB on July 26, 2023. Full stop. The deponent of the affidavit of July 26, 2023 is directed to file another affidavit, a second supplementary affidavit, explaining the reason why such memo dated February 5, 2020 was not brought on record. Full stop. Let the matter appear for further consideration under the same heading motion bolded on August 10, 2023. Bolded. Full stop. Next. Mr. Bhattacharya, you will have to take necessary instructions whether this memo only referred to the port trusts or also CDLB. As far as clause 9 is concerned, Mr. Bhattacharya, learned counsel appearing on behalf of the Union of Indias, is permitted to take necessary instructions in respect of
You are appearing for the central government.
in respect of clause 9 of the memo dated February 5, 2020. Full stop. Since the said memo is addressed to the chairpersons of all the major port trusts, as well as the chairman CDLB, it has to be clarified whether the additional expenditure is to be borne only by the port trusts or also by the CDLB in respect of the dependents of the ex-employees of CDLB for payment of family pension in terms of Rule 54 of CCS within bracket pension bracket closed rules, 1972. That was LAPITA server copy that attached.
One thing I just noticed, possibly that may explain away the reason why it has not been referred to. If your lordship takes this 2020 circular, handed over by my learned friend, that relates to class 1 and class 2 officers only. None else.
Let him come up.
In CDLB,
He has come up with all the orders passed in contempt application. Why he has not come up? Let him come.
but this is not relevant, perhaps.
At least let him come up and
Yes.
submit on affidavit.
It says, my lord, in the heading subject regarding class 1 and class 2 officers of port trust and document.
Let him come up.
But he was not an officer. Right?
না রুলস তো আর ডিফারেন্ট হবে না, ডিফারেন্ট এপ্রিলের নিচে
No, no, এখানে দেখো class 1,
ক্লাস 1 ক্লাস 2 তে
only for class 1 and class 2.
পড়েছি, তার মানে এই নয় যে আদার্স হবে।
Shiva, item number 61 and 62 on behalf of the petitioner praying for not to remand. Mr. Shanal is appearing, my lord.
Today I filed affidavit, my lord, affidavit.
এটা কি আমার?
Affidavit রেখে দিয়ে এটা 17th করে দিই।
ঠিক আছে।
Your lordship also
Who
directed
is appearing?
Mr. Shanal, Sarvananda Shanal.
Ashok,
Your lordship also directed to
Yes,
serve copy
yes,
to
yes.
the concerned authority lordship. May I?
exception,
No, lordship. Your lordship also directed to serve copy to the concerned authority lordship.
Answer?
Concerned authority, mines and minerals.
He is appearing.
State.
Report on affidavit on behalf of West Bengal State Minor Irrigation Corporation Limited within bracket WBS MICL bracket closed. As handed over in court today, is retained with the records. Full stop.
Your lordship also directed to serve copy to the state respondent lordship, but they refused to
Let the matter appear for further consideration under the same heading motion on August 21, 2023. Serve a copy.
your lordship also directed to serve copy to the state respondent, but they refused to take such action.
Can't be, madam. If you serve on the office of the government leader, it is not possible for them to refuse. I think 17th, Thursday. Previous matter, 17th of August. 10th August. You are supposed to only bring the affidavit to court. You don't have to give it to them. You are supposed to bring it on the adjourned date of hearing.
62.
Same motion.
I filed, my lord.
62 te order lekhe do. Same order as 61.
63.
But 63, I am appearing on behalf of the petitioner. But on the last occasion, on 20th of July, your lordship directed the Learned Council appearing on behalf of the BSF. But this is that matter. I am in custody 2 years, 1 month.
Yes, yes.
One of the
Yes,
co-accused has been enlarged on bail by the
Yes.
division bench. My lord, your lordship.
Mrs. Alam.
My lord. Mrs. Alam was there, my lord.
Yes,
She
she
was
was
supposed
here.
to file a list of dates, my lord.
Yes.
And I have prepared also a list of dates, if your lordship.
She was here. She was waiting.
My lord, may I take short pass over? My lord, I will call him. 60. Oh, so my lord, he is there. She is outside the court. Actually, board is, my lord, showing 62.
It is showing 63. I can see. Come back on the 8th. Seventh monthly list বলে আমি 8th বলছিলাম 7th monthly list.
Kindly give me 5 minutes time, my lord. I am calling her.
She's on her way. All right.
I have also prepared, my lord, list of dates. My lord.
Appearing in another court, Miller, and she's on leg, Miller.
Come back on the 8th. I'm not keeping it on the 7th because there's a monthly list on the 7th. You come back on the 8th. Ashu. The matter was taken up for hearing today. Full stop. An accommodation is prayed for on behalf of Mrs. Alam, appearing on behalf of the Union of India. Full stop. Let the matter appear for further consideration under the same heading motion on August 8, 2023, when it is expected that Mrs. Alam shall appear before this court. Full stop. ওইটা ডেটটাকে বোল্ডে করে দিন। Let the matter appear under the same heading motion. বলে দিন, বলে আর ডেটটাও।
One indulgence, my lord. Can this be?
এটা একটু দেখো তো উপরে যদি তুলে দেওয়া যায় 8 তারিখে রিটার্নেবল এর উপরের দিকে রেখে এইটা একটুখানি রিটার্নেবল।
Grateful.
Eight.
64.
I'm a petitioner.
64, my lord, I am for the state respondents.
For the answering respondent.
Yes, yes. My lord, by an order dated 20th July 2023, my lord, your lordship appointed me, my lord, to represent the state since none appeared for the state respondents. Now here, my lord, in earlier orders, my lord, state was directed to file a report. My lord, I have already informed the SDO Chacho. Yes, there are
Advocate, despite
yes,
so many notices was not
yes.
appear. So many notices were not was not appearing.
Yes, I have seen, my lord. My lord, your lordship, kindly give me 7 days time, my lord, to file the report, my lord.
One. From December 2022, we have come to July.
There are several directions, my lord. There are several directions, my lord. I have already, my lord, informed the SDO Chachol, my lord. Your lordship, kindly give me 7 days time. In the meantime, my lord, we will file report, my lord.
Madam, finally, we'll get somewhere. Mr. Rai Mukherjee, appears on behalf of the state respondents pursuant to the directions of this court. Vide order dated July 20, 2023. Full stop. Time to file report on affidavit is extended till August 11, 2023. Full stop. Exception, if any, by August 18, 2023. Full stop. Full stop. Next, matter to appear under the same heading motion, bolded, on August 21, 2023. Bolded.
Grateful, man.
Sir,
August 29.
I make a paper the petitioner regarding the appointment of Chief Legal and Defense Counsel under the State Legal Service Authorities Act, my lord. They have not appointed me on the ground, my lord, lack of desirable qualification, which is not computer knowledge. Your lordship on the last occasion was not satisfied with this explanation. They were to not bring further instruction, if any.
My lord, I am praying only today's accommodation, my lord, on behalf of Mr. Parthasarathi Bhattacharya. My lord, his legs on, my lord, court number 13. Only 2 days, my lord. My lord, there are 4 matter, my lord. There are 4 matter, my lord, 65, 95, 112, 115. All are in the same. And they are, my lord, the protected by, my lord, the your lordship's interim order. My lord, only 2 days accommodation, my lord. He is, my lord, stuck off, my lord, in court number 33, my lord. 13, my lord.
Tomorrow, if possible.
Tomorrow, my lord.
Tomorrow I don't take up these matters.
My lord.
All right, not today.
Not today, my lord. Deeply village, my lord.
$66.
Or I am for the writ petitioner.
For the response.
তুমি নাম্বার গুলো ইয়ে করে দিয়েছো তো? ওটা 4টে মামলা একসাথে নাম্বার।
This is my exception.
না 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 সবকটা নট টুডে করে রেখে দাও।
On the exception. I am filing my exception to the report. ওটা তুলিস না কেন বুঝতে পারি না, লাস্টে কি দিয়েছিল অর্ডারটা, তুলিস না, একটাও তুলিস না।
Yes, what do they say in their report?
My lord, the report says, my lord, at page 8 that the respondent authority directed the petitioner to deposit, to submit, my lord, the page 8 middle, my lord, last 3 lines. You are requested to provide the proof of submitting PAR for the year 2017-18 within 15 working days from the date of receipt of the communication which is necessary for disposal of prayer for pending promotion under CPS of WBACDCL. And in terms of that direction, it was issued by the additional general manager, WBACDCL. And second reminder, was given, in terms of that, petitioner acted upon page 10. আপনার 10-9-21 তারিখে আমি চিঠি পেয়েছি 2017-18 সালের PAR পার্সোনাল, দিস ইজ মাই লর্ড
Appraisal report.
page 10.
Yes, yes.
মাই লর্ড আপনার 10-9-2021 তারিখে আমি চিঠি পেয়েছি 2017-18 তারিখে।
Yes, পুনরায় PAR জমা দিচ্ছি।
Yes. দিয়েছি 9-8-2021, that is almost 3 weeks. Direction was within 2 weeks it was submitted because they had asked me to submit fresh because the original copy could not be traced out. In spite of that, after that, what they page 11, what they have stated, the manager HRA, in reference to your prayer, I am directed to you, directed to inform you that your prayer for consideration of next higher level promotion under CPS has duly been examined and was placed.
You are unable to provide within due time.
Yes. Within 15 days, my lord, I have also, my lord, submitted my original, my lord, my first application in my exception. My lord, kindly come to. They are only 7 days lakhs are there. My lord, my exception page 7.
Wait, one second.
My lord, I have submitted the personal appraisal and self-assessment report for the year 2017-2018 on 9th August 2021. And thereafter, again, I submitted the same to the the general AGM.
If
That
you
is,
look at page 8 of their report,
they have directed me.
they might have written this letter on 3rd of August, but when has this been posted? Because you have accepted it, I think, on 24th of August.
My lord, 24th August.
So the time has to start
From the date of, because
yes, they have, if you have received on 24th of August.
and my lord, the second reminder letter on 10th of September 2021. 10th of September. Here, my lord, the petitioner, in terms of the order of this honorable court, petitioner prayer for, my lord, the enhanced grade pay in respect of this pensionary benefit had already been granted by this general manager, and accordingly petitioner is entitled because
during some period, my lord, petitioner was suspended due to, my lord, criminal case. Subsequently, he was allowed to join, and my lord, petitioner was acquitted from, my lord, criminal charges on 22nd March 2018, and petitioner retired on, my lord, 30th
All
April.
that I have recorded in the
Yes,
previous.
already, my lord, recorded within, my lord, yes, my lord rightly pointed out. Not only that, my lord, I am pressing that document, the personal appraisal scheme. Also, my lord, given duty upon the recording officer, my higher authority, my superintending authority, to supervise the. Kindly come to page 12. Personal appraisal. This is not my fault, and if I committed any mistake, my higher authority will look into the matter. My lord, page 12. It is the scheme performance appraisal and self-assessment. This is the scheme wherein, my lord, the policy has been formulated for giving.
So is it their only point that they have?
Only.
The PARs should have been with the company itself.
And if you also have a look into page 14 of their report, the duty casted upon procedure says that the 9 Roman 4, the initial reporting officer shall be responsible for submitting the PAR covering all employees under him within 30th April every year to supervise the reviewing officer, who is in his turn shall transmit them with the observation and countersigned to the next higher receiving officer within 15 May every year. In no case the reviewing officer should deny such a report for more than 10 days. And thereafter, my lord, 6. Initial reporting officer, reviewing officer failing to draw up.
It's all right. It's yes.
Kindly come to page 27 of the writ petition. 28. Pursuant to the Honorable Court's order, a reason order was passed wherein, my lord, page 28, column 4, serial number 4, the petitioner Sri Vishwanath Mundal is eligible to be considered for getting third level promotion as per rules of the company if all necessary formalities are to be followed. Now, my lord, kindly come to the page 12. There is, my lord, report.
Page 12 of the writ petition.
Of the report. That is performance appraisal and self-assessment report. Page relevant procedure, my lord, page 14. Clause III, performance appraisal report should be written after 31st March every year. Every employee shall initiate action for submitting his self-assessment report, performance appraisal report positively by 15th April every year to his immediate controlling officer. This is the provision, my lord. Petitioner was retired 2018. Subsequently, this order was passed for in terms of the Honorable Court's order. My lord, then kindly come after that, passing that order, the petitioner was by letter at page 8. My lord,
page 8 of the
page 8 of the report, annexure R1. During hearing, held on 16th March 2021, that is referred, my lord, that page 28, General Manager's order. In terms of the order dated 23rd February 2021, passed by the Honorable Justice in the matter of so and so, you had stated that before your retirement, you had submitted PAR of the year 2015-16, 2016-17, 2017-18 at Raghunathganj in division. you are requested to provide the proof of submitting PR for the year 2017-18 within 15 working days from the date of receipt of the communication, which is necessary for disposal of your prayer for pending promotion under CPS WBACDCA. My lord, the petitioner did not respond to that letter. Then again we serve another letter, request for sending proof record of submitting of your PAR. You are requested to provide the proof of submission of PAR for the year 2017-18 by memo dated so and so. However, till date, no communication has been received from your end. Hence, you are once again requested to provide the proof of submission of PAR for the year 2017-18 within 7 working days.
Mr. Paja, he was to give you the self-appraisal report.
Yes.
The PAR is your responsibility. Whether or not the PAR has been drawn up or not, it is the responsibility of the company.
That is self-assessment appraisal report.
You are, yes, this is a performance appraisal report. That is the responsibility of the company. This is not the responsibility of the employee. The employee's responsibility is the self-appraisal report, on the basis of which you have to draw up the PAR.
That is my lord.
That is the rule. Now it has to be, because after he makes a self-appraisal, it has to go to a reporting officer. Then the reporting officer does whatever he wants to do. Then it goes to the reviewing officer. Now the question is whether or not the PAR is there with the company or not. Now you cannot shift the responsibility to him.
No, my lord, kindly consider that clause III.
Yes, after considering, I am
Performance
telling you.
appraisal report should be written after 31st March every
Yes, it is up to you. You
Every
write
employee.
whenever you want to write.
Then, my lord, every employee shall initiate action by submitting his self-assessment report.
Yes, that is what I am telling you.
That's why, my lord.
So you cannot ask for PAR from him.
No,
You
that
can
is
ask for a
self-assessment.
self-assessment
Yes,
report. Where have
self-assessment.
you said that his self-assessment report is not there with you? You are saying in your letter that the PAR has to be given.
That is my
Where
lord.
are you saying that he has not done his part of the job?
That's why, my lord, it has not been considered. Because
Please tell me, it doesn't appear from your letters. His responsibility is to give a self-assessment report,
in respect of all categories of
and you will have to draw up his PAR.
PAR.
Where have you said that he hasn't put in his self-assessment report?
In the letter, my
Show
lord.
me. Either in the letter or in the impugned order, where have you said?
No, impugned order as my lord, they have, my lord, not considered because of their incomplete of PAR. That's why, my lord, it has not been considered. And when he has, my lord, retired so long back, my lord, ago. Therefore, my lord, and it in page R3, he has stated that he has submitted up in 10/9/2021 in R3.
9/8.
Page 10.
98.
9/8. Yes,
9/8.
9/8/2021. নতুন করে পিআর জমা দিয়ে কাগজ জমা করিলাম. That's why he has.
I am not. You have to show me that you have acted in terms of the
that
rules.
in the letter, my lord, it PAR was mentioned in the letter, but it is generated from self-assessment report. That is, my lord, what I am kindly in my statement, I have stated in paragraph 5, 6, and 7.
You might, but then the documents don't support it.
And my statement, আমি জমা দিয়েছিলাম. And the Raghunathganj division received the letter on page 8 on 24th August 2020.
Why will it submit the PAR to you? And where have you said that you have meant self-assessment report and not PAR? Where have you said that? That you are asking for self-appraisal report.
বুঝতে পেরেছি।
My lord, in that scheme, my lord, in the scheme, it is assessment report, performance appraisal report. Positively by 15th April. That's why, my lord, I think they have mentioned the PAR. Because it has been assessment report, self-assessment report / performance appraisal report. In the, my lord, scheme which I have annexed. That is, my lord, I cannot develop the language as mentioned in the scheme. And
You don't have to develop the language mentioned in the scheme. The scheme is perfect. You have to see your executive action on your part. Scheme has no problem.
And Mala, kindly
and
come
that's
to
why only
Roman 7, page 14. There is a penal action at every delay. At each level, the concerned higher level officer should send a stricture to the officer at the lower level with copy of his own controlling officer to the secretary WBACB. Such sir may go against the reporting officer. So if any lower level officer is failed to comply with the provision,
Mr.
then
Chattopadhyay, please try to understand what has happened. You have not given your self-appraisal report. They have not applied their mind. They are proceeding on the basis of PAR.
yes,
This
yes,
is the
yes,
fact of the
yes.
case. Because unless you give your self-appraisal report, they cannot draw the PAR. There is complete non-application of mind on their part.
My lord, my
To
lord,
the mind of this court, PAR cannot be given by the officer,
my lord.
by the employee. PAR has to be drawn by the officer,
Officer,
and PAR has to be retained by the company.
my lord,
The entire confusion is because of the executive action on their part.
my lord.
Now what you will do is you will give your self-assessment report to them, let them draw the PAR, and then you come back. Where is your self-assessment record?
My lord,
What have you submitted on that date?
I have submitted, my lord,
You bring it by way of an affidavit.
my
What
lord,
have you posted?
I have stated, my lord, in my representation that copy of the
What have you posted to them in September? Where is that document?
only, my lord, the receipt copy is there. The, my lord, the self-assessment report is not.
It's not there.
Because only, my lord, the language is
What have you submitted on 24/9? Do you have it with you or not?
not 24/9, my lord, 9/8.
Page 10 of the report.
My lord, kindly see the language. 17-18 সালে PAR জমা দিয়েছিলাম রিসিভ করার প্রমাণ দেব বলে।
Oh, the PAR's date, I'm not concerned. You have submitted some document on 24/9.
My lord,
What have you submitted? That you
my lord,
have with you
পুরাতন
or not?
ইয়েস, my lord, কিন্তু পুরাতন কপি খুঁজে পাইনি বলে পুনরায় PAR জমা করেছি তারিখ 9/8/2021, 9/8/2021। নতুন করে PAR জমা দিয়ে কাগজপত্র জমা করিলাম। my lord, that may be
জমা করছি তারিখ
করিলাম জমা করিলাম, and it is received by the competent authority. There is a seal of the Raghunath
Where
division.
is 9/8's document?
It is lying with the, my lord, the Raghunath division WBSCD seal.
Where have you deposited? This letter is stamped. Where is 9/8's stamped document?
9/8 stamp, my lord, before kindly come to page 9. Page, my lord, my exception, page 7. Kindly consider the language written by the petitioner. Submission of PAR SAR for the year 17-18 against the
Yes, so
non-availability.
this is the one. He must have submitted a self-appraisal report. Where is
Certainly,
the
madam.
copy of that?
I have deposited it. Now I am giving to submit a fresh copy of PAR, SAR for the same period. Therefore, I request you to necessary action for settlement of my case. My lord, language is, my lord, kindly consider the
Terrible.
language. Page 7 of my lord, my exception R1.
I am looking at it. Language is terrible. So do you have a copy of the SAR with you or not?
Just now I cannot because I just now I
Ashun. You take instructions.
my lord.
Exception to the report on affidavit as handed over in court today is retained with the records. Full stop. Mr. Panja, learned counsel appearing on behalf of WB ACDCL submits that the petitioner was required to submit PAR by a letter dated August 3, 2021, issued by the manager within bracket HR and A bracket closed full stop. However, since no PAR was submitted within 15 days, again, a reminder was given on September 10, 2021 by the additional general manager within bracket HR and A bracket closed full stop. The petitioner was required to submit the PAR within 7 days from the date of the communication of the letter dated September 10, 2021. Full stop. Next. The petitioner submits. Now the petitioner submitted his PAR on September 24, 2021 after expiry of the period of 7 days. Full stop. Since the petitioner did not submit the PAR within the stipulated period, the petitioner's prayer for being considered for promotion was not done. V-Day order dated November 8, 2021, issued by the managers within bracket HR and A bracket close full stop. He draws the attention of the court to the guidelines of WB ACDCL in relation to performance appraisal reports, PAR, bracket closed, and self-assessment reports within bracket SARs. Esta choto hobe, SARs, bracket close, full stop. He submits that before a PAR can be written, every employee is required to initiate such action by submitting a SAR to his controlling officer. Full stop. However, since the petitioner did not do so, he was not considered for promotion. Full stop. Next. Mr. Chattopadhyay, learned counsel, appearing on behalf of the petitioner, submits that upon receipt of the letter dated August 3, 2021. The petitioner submitted his PAR-SAR on August 9, 2021, full stop. Such letter was received by the authorities concerned by their stamp and seal, full stop. Therefore, there was no legitimate reason for non-consideration of the petitioner's prayer for promotion, full stop. Next. Considering the submissions of the parties and the materials placed on record, this court permits Mr. Chattopadhyay to bring on record a copy of the document handed over to the authorities concerned on August 9, 2021 by the petitioner by way of a supplementary affidavit, full stop. Next, let the matter come up for further consideration under the same heading motion, bold. By when? 17th you can bring? By 17th of August or 21st? By 17th you can bring? By August 17, 2023. Serve a copy. You have understood, Mr. Chattopadhyay, what is the confusion?
SAR and PR.
SAR and PR, and what has he submitted on the 9th? I have to see.
Yes, yes.
One thing, my lord, instead of Mr. Paja, it should be Mr. Rai.
Mr. Rai and Mr. Pajai keep on because you usually appear with Mr. Pajai. Yes, Mr. Rai. Yes.
And they cannot also shift their liability if I fail
no, I am
because
not
the
shifting
controlling officer, the reporting officer, there is a procedure for taking steps against the controlling officer by the higher authorities.
No.
Yes, I'll come to that. First, let me see what you have done. First step first, you
I
bring
think,
it on record.
They
Then
got it. Otherwise, they should have raised objection. Yeah, you did not file it. They did not deny. Only their condition, you could not
27,000
produce
employees.
within time.
It is not
You
possible.
could not produce within time. That is their contention in the rejection letter. I will submit.
yes, I have seen the rejection letter. Let me just see that you have done your work within time.
Yes,
First, you prove you're right, then
got
we will
it.
come to how bad they are.
Grateful, my lord.
All right.
It is also pleasure to argue before your lordship also.
It is also a pleasure to listen to you.
Thank you.
67, I beg to appear on behalf of the petitioner, my lord.
I appear on behalf
This is that
of
matter regarding
Then
civil
Mr.
volunteer,
Prabhu
my lord.
Mukherjee, Lord, says.
Disengagement of my service without my lord
Evident.
granting any opportunity. My lord, on earlier occasion, my lord was pleased to direct the state authorities to bring a report, fresh report. My lord, what happened, my lord, in this matter, I have
Yes.
It's a main fact.
So where have you said that you have been charge sheeted and you have been,
My lord, let me. My lord, I have been charge sheeted. I have annexed, my lord, my one status report. I have not, my lord, suppressed that no criminal proceeding is, my lord, pending. I have stated that in my petition, my lord.
so
And my
now
lord,
they have
knowing-
their
knowing, knowing that well, my lord, they have, my lord, selected me as a civic volunteer. My lord, all of a sudden, my lord, out of nowhere, my lord, without showing anything, my lord, any misconduct, they have, my lord, disengaged me. That was there in their knowledge. 2013.
there are 3 cases pending against you.
My lord.
Next case is
2
pending.
cases are of August and no, of July. One is of July 3, 2013. The other is of July 10, 2013.
My lord.
But there is another case which has now been filed against you in 2014.
My lord, this is 2014. I have been
2014.
I have been disengaged, my lord, thereafter.
No,
Second paragraph raised.
you have been engaged
No, no.
in
disengaged,
October 2013.
my lord.
As per the report, you have been engaged in October 2013.
No, no. I have been disengaged, my lord.
That is what you say also in at paragraph
Paragraph
22. And now you are also involved in Gram Panchayat.
No.
You are an
This
elected
is the
member.
earlier term, my lord, not this term. And my lord, there is no bar, my lord, for a panchayat member to selected as a civic volunteer.
But they have their guidelines. Criminal cases are pending against you.
But knowing fully well, my lord, they have been
Even if
selected.
there was a lapse in their
Yes.
selection process, but they have their own guidelines that there can't be any criminal case pending against you.
My lord,
Page 23,
my lord.
page 24, D1.
Yes, my lord. But
D1, page
my lord,
24.
but
Yes, so
my
where
lord,
have they gone wrong?
no, my lord. They have, knowing these things, my lord, they have selected me. I have not suppressed anything.
You have
before
not
them.
suppressed. There is another case which is pending
My lord,
against you
later-
since
later-
2014.
Later on, my lord.
Yes, where is that?
My lord, in this petition, my lord, let me take instruction, my lord, regarding that. My lord, only thing, my lord, so lordship may come, my lord, at page. At page 46, I have annexed my only annexed my medical documents, my lord, of my only son. He is a acute patient of my lord thalassemia. This meager income, my lord, is very helpful for me.
Ashun. The petitioner was engaged as a civic volunteer on or about October 2013. In or about October 2013. Full stop. The engagement of the petitioner has been extended
Till January 2019.
from time to time. The petitioner has been disengaged sometime in January 2019. Full stop. Petitioner has made several representations before the Superintendent of Police, Purbo Bardhaman, and also the officer in charge, Asagram, AUS Asagram Police Station. Full stop. Next. You're Mr. Bhattacharya?
No, my lord. I'm myself Gaurav Ghosh, led by
Mr. Ghosh. Mr. Ghosh, learned counsel appearing on behalf of the petitioner submits that the petitioner's representation dated March 2, 2021 has not been considered till date. Full stop. Next. On March 20, 2023, Mr. Mukherjee, learned additional government leader, was directed to take necessary instructions in the matter. Full stop. Necessary instructions are handed over on behalf of the state authorities today. Full stop. Such instructions are retained with the records. Such instructions dated April 2, 2023 are retained with the records. Full stop. It appears that three criminal cases are pending against the petitioner. Full stop. Osgram P full stop is full stop case number 169/13, 182/13 and 223/14 are pending against the petitioner. Full stop. Under the rules pertaining to civic police volunteers published in the Howrah Police Gazette dated October 1, 2011, it appears that involvement in any criminal case will render termination of voluntary service of the petitioner. Full stop. Next. In the light of the facts stated herein above, this court finds no infirmity in termination of the petitioner's services as a civic police volunteer. Full stop. Accordingly, WPA 3835 of 2023 bolded is disposed of. Full stop. Server copy, certified copy. Is disposed of, is dismissed. Server copy, certified copy.
Grateful.